Well, it's interesting to think about some of the old timers. It was true advice. Really? Watch it. It's in my car. Yeah.
Can you teach me how to get on the thing?
Good morning, everybody.
Good morning.
Is it charged?
Exactly.
Or just come to your neighborhood.
Yeah. Yeah, even if it doesn't snow down here, it will up there for another month. Although it's beautiful right now, so.
I see.
Yeah. Yeah. Yeah, but you are too. Yeah.
Traffic.
No, thank you.
Enough yet, do we? Do enough?
About what?
I don't know what that means. Do we have a Twitter? You guys don't do Twitter, do you? Facebook? Good. We're talking about. Oh, start. You know how bad it's going to be.
And you'll call to order this April 13th, 2015 hearing from our conservation. With that, okay, well, roll call.
Chair Compton, I think that's appropriate. Commissioner Allward?
Here.
Commissioner Benton?
Present.
Commissioner Craig? Commissioner Compton?
Here.
Commissioner Hawkins?
Here.
Commissioner Holton?
Here.
Commissioner King?
Here.
Commissioner Spielman? Commissioner Wolk? I believe we do have quorum.
Thank you very much. I just thank you for being here momentarily. She had a family issue to address. Her arrival. You have a form. Cheers. With that, all your attention to proceedings. Do you have any action you have to take on those? Move to approve. Is there a second?
Second.
Any discussion? Hearing none.
No, okay. Mr. Chair, I just wanted to. Okay. This one might be. Is this one working? Okay. All right. So I just wanted to point out that last night while reviewing the proceedings, I had a crushing blow to my ego because it wasn't noticed that I wasn't present on the second afternoon of our hearings. And so it should probably be noted as such, and I imagine that means that the vote on the final docket number, which was docket number 1410 GA06, the vote was probably 5-1. So if that correction could be made to the proceedings.
No, we'll look into that. With that correction, any other discussion? Have a motion second, all in favor, indicate by saying aye.
Aye.
Opposed, same sign. Proceedings are approved. Let's have a report from the Executive Director's Office.
Thank you, Mr. Chairman. Is that working? If, well, okay. The legislative session. It's always. It has been a relatively quiet session. Yes, and one of the things that was a priority for us that absolutely had to be done this legislative session was get the task force recommendations for FTE approved, both for CDPHE and for OGCC. The JBC approved that. It is in the long bill, and we will be getting our 12 FTE for OGCC, and Director Lepore will commence hiring, maybe even begin the process before July 1, but we will have those folks on board to continue to make sure that we have not only the best regulations in the country, but the staff necessary to make sure that those regulations are adhered to. And so that's good news. Much thanks to our friends in the General Assembly. Those were both supported on bipartisan lines, so that's great. Director Lepore and Director Wolk and I will be presenting on the 29th at the Energy Symposium in Rifle. It's kind of started as a boutique energy forum, and I think now is, they could be pushing 200 people at that symposium this year. And I would encourage you to take a look at the agenda, and if you're inclined, attend. It covers the gamut from macroeconomics, oil and gas dynamics worldwide, to some of the unique issues that we're facing here in our country and in the state. It covers the full gamut. It should be very entertaining, and I'm looking forward to making a presentation there. We continue to forge ahead with the Colorado Water Plan. We also are looking at California as an opportunity, as horrible as their situation is. It does provide us something of a case study as to what could happen here in Colorado. And so I think it is crystallizing our thinking and framing our discussion in ways that brings a sense of urgency that is important to Colorado as we wrestle through the water plan and the state's future with water. The governor has, in the state of the state, initiated Colorado the Beautiful, a program to get young people out to protect our incredible places here in Colorado, to build a world-class trail system. We're pleased and privileged to be in charge of that at DNR. We're working closely with our friends at GOCO, as well as KinGart on a bike initiative. And so there's a lot going on, and it's one of those warm and fuzzy things in DNR that come along far too rarely. And so we are picking this up and excited, and maybe turning to folks on this commission for help as we comprehensively look at our outdoors, getting people outdoors, and keeping Colorado the place that we know and love. So, Mr. Chairman, that's the extent of my report. I'd be glad to answer any questions if you have any.
What was the dates on that deal and rifle
29th and 30th.
of this month?
Yes. And I don't know whether there are costs to attend, but if there are and members of this commission want to attend, we'll certainly cover those as part of your duties here. I think it'd be very informative, and especially to get over there and listen to some of the dynamics about natural gas and the peons, some of the different challenges that they're facing compared to the wet plays in the Niobrara. So it would be well worth your time.
It's not the first time. Probably won't be the last.
Or last.
Other questions for Mr. Kane? Commissioner Benton?
This is actually for Commissioner Holton. It's called the Energy Environment Symposium. It's put on by Colorado Mesa University, and you can just Google that, and all sorts of information comes up.
Thank you.
Okay. Director Lepore.
Thank you, Mr. Chairman. I'd like to start with some personnel changes. Most obvious one immediately to my left. Ms. Murphy has joined us as the new and really the first ever Hearings and Regulatory Affairs Manager. We're very pleased to have Julie on board. Julie came from the Attorney General's office most recently, had been in private practice before that. Julie has a JD and, I don't know, 2 or 3 master's degrees in various environmental related subjects. She'd been working with the commission over the last 6 or so months, in addition to her duties at the AG's office with the Division of Mine Reclamation and Safety. She's done great work for us. On the AG side, we are very happy to have her in-house and on board. Welcome aboard.
Ms. Murphy.
Thank you.
I think she would describe her first week as the proverbial fire hose.
Yes.
Peter Gowan has been promoted to enforcement supervisor. Peter has long been the anchor of the enforcement staff, and we're pleased to be able to recognize his fine work with this promotion and commensurate raise in his salary. So congratulations to Peter. And we have a new staff person in our imaging systems administration and a new staff person in the records administration tech. That's Darla in the records administration tech, also known as the public room manager, so a new face in the public room, and Allison Rothermel in the imaging systems administration. The lead story on our staff report is the imminent unveiling of a new COGCC website. I've talked about this for really 2.5 years since I started. It has been a challenging project, but we have pushed out the new website to some beta testers, including all of you, and we think it will go public, fully public, before the end of this month. We have a little demonstration that will come here next at the end of my report, but I want to acknowledge Chris Eisinger, who's sitting over here. Simply put, we would not have a new website but for the fine work that Chris has done on this project. Chris has invested himself completely in this, owned this project, and really brought it to fruition where many before him had failed. So we're very, very, very grateful to Chris for his work. He learned a new software programming system to get this done, navigated the very, very tricky waters of the Office of Information Technology, and has us on the cusp of really a new day for the agency. So thanks, Chris. Other news, the staff has been pushing out a number of compliance documents recently, and this ties somewhat to the governor's task force recommendations. One of those recommendations was that we work carefully and closely with the regulated community to enhance everybody's understanding of rules and expectations and our interpretation of those rules and what it means to be in compliance and what it means to be out of compliance with some of those rules. So staff has worked up half a dozen or so new compliance documents over the last several months. Those are being posted on the website. We have a series of meetings scheduled for the regulated community, and of course those are open to the public as well, so that we can, again, walk through how we interpret those rules and how we expect to apply those rules. And that effort has been led, well, it's a staff effort, but Dave Coleman is the sort of coordinating force there, and Dave will continue to reach out to the regulated community to see that we're all on the same page with those. I want to highlight some stats as usual, and then I'm going to ask, again, Chris to present on the website. And we also have a presentation from the Division of Water Resources and Stuart Ellsworth on the DWR's determination that the Pierre Shale aquifer is a source of drinking water and what that means for oil and gas operators as far as our rules go. So highlights on the stats. Permitting times for Form 2s and Form 2As over the last 6 months are at 43 days for a Form 2A and 46 for a Form 2. Most of you are aware that our stated goal is 30 days to turn around permits. We are finding that that is increasingly unrealistic given the ever-increasing complexity of those documents, all of the information that is required, all of the fields that require review. So I just wanted to put that out that, you know, statistically it's borne out that it's taking us longer than 40 or 30 days. We have recently instituted our first ever rejection policy, where we will no longer accept applications that don't meet a bare minimum threshold of completeness with the appropriate data, the appropriate attachments, et cetera. So for the regulated community, we've had those discussions with the regulated community, and we will continue to kind of, I think, raise that standard of what is required if you want your permit to be accepted and put into the in-process status. So that's where we are, 40-ish days rather than 30 days. Another statistic that jumped out at me as I went through the report is the drilling rig count. All of you are aware of what has happened with oil prices over the last several months, and for me, that is reflected very strongly in the drilling rig count, which has declined from the mid-70s in November of 2014 to 38 active drilling rigs as of last count. So the active rigs is a very good gauge for us of the level of activity. It means a lot of rigs have been laid down over the last several months. I wanted to look at drilling permits kind of in that light. And so in terms of the drilling permits submitted to the agency, last year, on average, we received 300 permits per month. I'm sorry, 350 permits per month over the course of 2014. In the first quarter of 2015, we're receiving about 300 a month. So it's off 15% or so, but not by a huge amount. So I think that's more of a forward-looking sort of measure and statistic. And so operators still seem to be cautiously optimistic, I think, about the longer term. You all know that those drilling permits are good for 2 years, so they can get them in the queue and may not have to do anything immediately. Another interesting statistic for the first quarter of 2015 is the horizontal level of horizontal drilling activity. Last year, horizontal wells comprised 58% of all permits that we received. Year to date this year, we're at 65. 65% of all applications are for horizontal wells. So I think that is a continuing trend. Last year compared to, 2013, it was relatively flat. So we're seeing a little bit of an uptick there, maybe. And then last on the statistics, we are very near the time of year where we try to say that the production records for 2014 are final. All right, remember that production reporting lags. Operators are not required to report production until 60 days after. I think, somebody tell me if I got that wrong, 60 or 90? 45? Thanks, Jane. 45 days. So there's a lag. But our goal every year is to say by April 15th, this is the production for the last year. 2014 was a record, all-time record year of production, okay? And 2013 was an all-time record of production. In 2013, there were 65 million barrels of oil produced in Colorado. In 2014, we are at 93.5 million barrels. That is a 44% increase in production year over year. I find that a staggering number, to be perfectly honest. If we go back a decade, year over year production was about 5% increase. In 2009, it started hitting double digits. We've seen 20 to 25% increases each of the past 3 years or so. But to go from 65 to 93 just tells you the impact of, frankly, the horizontal development, hydraulic fracturing. With that, Stuart, are you and the Division of Water Resources ready? Okay, let's.
Mr. Chairman, I need to revise and extend my comments. I forgot to follow up on the citizen-initiated enforcement action process. As I raised at the last meeting, we received an opinion from the Attorney General saying that you could make an argument that our process is not consistent with the statute that limits the enforcement action only to the OGCC and staff, and that we need to kind of clean that up procedurally. I discussed it last time. What I'm proposing and asking Director Lepore to do is kick off that process. We'll have a discussion in May and a final adoption at our July meeting to get that process in alignment with where the Attorney General's office thinks that we are on completely stable ground. So I wanted to bring that up to your attention. Thank you.
Thank you.
Stuart, thank you. Go ahead. And then we'll have Chris Eisinger after that on the website.
Sure. Okay.
Commissioners, thank you.
I've forgotten who you are.
Oh, thank you.
Well, not really, but.
Stuart Ellsworth, Engineering Manager of the Colorado Oil and Gas Commission. And with me, I have two representatives of the Colorado Division of Water Resources, and we're going to discuss the Upper Pierre aquifer. I believe you were handed out a draft document that we worked with operators on one previous occasion to create this, and I want to thank the Division of Water Resources for kind of bringing this at least forward to our attention, and the use of that they are defining this as an aquifer that has a usable water supply. It's not that we weren't necessarily aware of this. We kind of dealt with it on a well-by-well basis. One of the key points I want to draw your attention to, not necessarily walking through this in detail because it is kind of in a draft stage, but our current rules allow us and give us the ability to protect this aquifer with steel and cement. And so we're not suggesting this is a new rule. We just wanted to bring it, one, to the operator's attention that we are going to try to cover this aquifer, and the second, to bring it to your attention as we kind of move forward. Along with the Division of Water Resources, I want to thank the operators for working with two engineers I want to make reference to, Mike Hickey and Dirk Sutphen, two engineers that kind of worked with the operators to create this. And we're currently reviewing permits that come in. And this area of discussion is in northern Weld County, what's known as the Cheyenne Basin. Yeah, so we met with the operators once about a month ago and created this draft and drawing it to your attention. With that, I think I'd like to kind of move over to the Division of Water Resources, let them introduce themselves and introduce you to this, the Upper Pierre aquifer.
Morning, Commissioners. My name is Matt Sayers. I'm with the Division of Water Resources. I manage the Hydrogeological Services branch at the division, and with me is Kevin Donegan, our senior hydrogeologist. We also have a senior hydrogeologist who has worked. This doesn't sound like.
I think it's functioning okay, isn't it? Yes.
Okay. Another senior hydrogeologist who's going to be retiring soon, and Kevin is taking his place. His name is Ralph Topper, and he's really done a lot of the heavy lifting on this project that really became evident to us in the last year and a half, that the Upper Pierre aquifer is a viable aquifer in many places, and we've been getting non-tributary requests for non-tributary determinations, so petitions to the division as well as water court applications for non-tributary water in what is called the Upper Pierre aquifer. I know in oil and gas, a lot of us for a long time have thought of the Pierre as one solid, very thick shale unit, and predominantly it is. But there are zones of fine sand and silt, and in the upper part of the Pierre, as you move from a depositional environment of open marine up into the Fox Hill sandstone, where you have shore face facies, that's a conformable sequence. And so you start getting some material, sand and silt material that are forming some of these beds. And we're here to sort of outline the nature of that, the geographic nature of that aquifer as we know it right now, and also the physical nature in geophysical logs, so you get a little bit of a handle on what we're talking about in terms of the Upper Pierre aquifer. So on the screen right now, you see a map of essentially northeastern Colorado. Got the South Platte River going along in that geography, and the town of Greeley is located right there. Fort Collins, for reference, is a little bit over to the west. Yeah, it's hard to see just a little bit west of there, but so that's for just placing where we're looking at. We're mapping out really this aquifer right now north of the South Platte River. To be clear, we don't know how far south this aquifer might extend. There is some evidence from a 1977 paper in RMAG that there are similar units on the Upper Pierre in the Colorado Springs and east of the Colorado Springs area. So potentially this aquifer extends over a large area of eastern Colorado. It's not what we would normally call a significant aquifer because of the nature of it. It's predominantly siltstone, so the permeability isn't great, but it does carry water and can transmit water to wells. Just outline some of the geology. The geology you see here is by Glenn Scott of the USGS, and starting at the northern border of Colorado in the light orange is the Ogallala Formation, which is tertiary, and we'll work down section here. In the darker orange is the White River Formation, and at the base of the White River there's an unconformity that sits on top of Cretaceous sediments. So those White River sediments do erode into
there's an unconformal sequence on top of the upper Cretaceous. Below that, depending on the where that unconformity sits, is the Laramie Formation.
Would you let me just interrupt you for a moment and see if we could get one of those magic
I've got one.
pointers for
Sure. That'd probably be a little bit easier. Sorry, I didn't want to blind people over here, so if I do, just yell. Okay. So Ogallala up here, White River in the darker orange, and then the Laramie. Right here you can see the symbol, so the Laramie Formation in this yellowish, and then the Fox Hills in this darker yellow, outcropping towards the mountain front, and then along the where the South Platte Valley is cutting in. And then just that, and you can't see it well on this map, but on the next one we'll select out that geology. You'll see the Fox Hills Formation is exposed in some of these drainages, and especially this one here, which I believe is Cedar. Is that right? Okay. And this one here, which goes up near North Platte Reservoir, just also for reference, Sterling, Colorado. Let's go to the next map. Okay, so our cross sections again are shown on here. We've selected out the Fox Hills in this greenish color. So that's the outcrop of the Fox Hills, and then below that is the pier. Here's the upper pier transition zone as it's referenced by Glenn Scott. And this upper pier transition zone is more of a geologic pick, not a hydrogeologic pick. So the upper pier aquifer is within that upper pier transition zone. And again, it outcrops over here towards the mountain front. And then the middle pier in dark green would be below the zone that contains the upper pier aquifer. One of the other things that's important to note on this map are these pink areas. These are the areas where we've received non-tributary applications for water underneath these areas in the upper pier aquifer. Now, the upper pier aquifer has been used through time, especially in areas where there are no other viable water sources, no other viable aquifers, by stock wells. And of note, the town of Raymer has actually used water from this upper pier aquifer for quite some time. Just recently, they came to Division of Water Resources to actually identify this aquifer as a non-tributary source, which allows them not to augment water to the South Platte River with that determination.
What's the approximate depth? Surface to?
Well, it depends on the area, but down in this area, say the New Raymer area, depth to the top of that aquifer would be maybe 500 feet. And that well, if I remember right, extends to about 1,200 feet. Yes.
Is it being charged all the way from the Front Range? Essentially, is that where your charge point is for the aquifer?
That's a good question. I think it's a tight enough unit that it's difficult to say that it's been charged continually. I think the water that's in there may be older water that's meteoric water, so it's not connate. That's been preserved in that formation, probably dating back to the time of the erosion on top of the Cretaceous formations and before deposition of the Tertiary would be my guess.
If I might interrupt, I just wanted to note for the record that Commissioner Wolk has arrived.
So the next thing we'll look at here is a type log. That type log is in this location right here. And one of the other things I will note is that we have the Upper Crow Creek designated basin. And that's an area where water has been identified to be treated differently by water resources. It's not tributary. It hasn't been identified as non-tributary, but the predominant use of water in that basin, even though there's the Upper Crow Creek does the drainage flows through that area, it's commonly dry. So the predominant use is groundwater. It's been designated as not tributary to the South Platte River. And so water there is treated a little bit differently. To my knowledge, there hasn't been an application in that area, but people are pursuing other aquifers and other uses that this water has been applied to. And for these non-tributary applications, several of them have been for frack water for oil and gas operations. That's one of the reasons we're here, is that in some ways they've developed this aquifer to the point where people see it as a viable resource and are going after it. We've got also agricultural applications for that water as well. Okay. So this is the type log. We'll start again from the top and work our way down. This is not going to the top of the whole section, but just at the base of the Laramie Formation. You can see the Laramie Formation here, shales and thin sandstones, also some coal beds in there, fairly thin, up in the Cheyenne Basin. As you come down, look at this normal resistivity. This is a resistivity curve here. This is a SP potential curve on the left. And then this curve over here is an amplified resistivity log. So it's 10 times amplified. So we have those shales and some sands in the Upper Cretaceous moving down into the Fox Hills. You get some blockier shore face sands in this area, especially right in here. You come down to the zone at the base of the Fox Hills, which is a conformable sequence, and often you have some sands coming in the base of this very shaly sequence. We will put the base of the Fox Hills at the base of the last good sand within that sequence. And then we end up with about a 200-foot zone of what I would call essentially dead shale in terms of the geophysical log. It's a pretty good shale package with very little silt or sand in it. Then you come down here and you can see the difference in the character of the log between this shale, and we would define this as a confining layer for this aquifer. You get a slight increase in that base normal resistivity. And then if you look to the right of that, you see the amplified, and you can see that difference a little bit better on the amplified. And then at the base of this section, so this ranges from 500 to 1,000 feet. Most of the time it's between 600 and 800 feet, but it can vary to that extent, 500 to 1,000. Then at the base of the section, try not to get you in the eyes. Again, a very dead shale section. Again, a pretty good confining zone right there. So this is the section, that orange area is the upper pure aquifer, and producers are finding water that's producible out of there. From what I've heard anecdotally, getting values up to 200 to 300 gallons per minute initially. Whether that continues over time is a whole nother question, but it is a very thick section. So even though it's fairly tight, those siltstones will produce water over that thick interval. And one other thing to note here is that we've set a baseline to identify what the difference between shale and sand in this section. And you can see here, I believe it's a 6 ohm, up to the top. Yeah, there's a 6 ohm shale line and an 8 ohm sand line. And that zone in between, you can't call that sand, that's producible sand. When we count the number of feet of producing aquifer, we'll use that 8 ohm line generally, if the log is well calibrated. And so we see over here a little bit of sand colored in yellow within the aquifer. And as it compares to the Fox Hills, you can see we're just getting a little bit of sand here. We've got, you know, tens, almost hundreds of feet of sand within this section. And we're getting 50 feet here, 50 feet there, and 10, 20 in that area. So just to show the difference in what we would call a real aquifer like the Fox Hills. This is a real aquifer, but it's newly developed, and we really haven't thought of it in that way in the past. Let's go to the next one. So the next two slides are cross sections across this northern Colorado area. And this is an east-west cross section. So the town of Greeley is right about here. And this is Pruitt Reservoir is over here. You can see the valley of the South Platte River out to the east. And you can see the importance of the erosion along the South Platte Valley. This is the aquifer here, extending to the east. You can see the depth on the western end. These are 100-foot increments, so about 4 to 500 feet to the top of the aquifer over on the west side. And as you go to the east, that maintains about that depth until you get over to the South Platte Valley, where this aquifer actually is exposed at the surface and does contribute flow to the South Platte River in that location. Now, because of its properties, as you get away from the live drainage in the South Platte and its tributaries, this aquifer could be non-tributary just because of the tightness of the aquifer. But as you move closer, it will be tributary.
How far away do you have to get?
That's what we're trying to figure out right now. We've had a number of applicants come in with analytical models, and we pretty much have said this is this aquifer and its definition, we need a little bit more robust modeling. So a couple have come in with numerical models, and we're assessing those right now to see that they're viable. But I think that line is roughly 15. Yeah, it depends on the pumping rate in part. That goes back to the definition of non-tributary, which depends on the pumping rate of the well. Yeah, the north-south. So this one shows a little bit more of what's happening. So you're looking west. This is the South Platte River. This is the south. This is the north. Here you've got the White River Formation sitting unconformably on top of Laramie Shales. Again, that surface, this is an unconformable surface, and it's cutting into those Laramie Shales, and then present day erosion surface cutting into the Fox Hills sandstone, then the confining layer within the Pierre Shale, and then the Pierre Shale aquifer. And you can see this stays essentially confined at this location, but further to the east, as we saw on the last cross section, the South Platte alluvium is in contact with the aquifer. That pretty much outlines the aquifer, its geographic location, and its character in logs. I'd be glad to entertain any questions that you have on this. And of course, our interest in this is that this is a viable water source. It has been used for stock watering. It has been used for municipal watering. It's being also newly used for frack water. And it's going to be a fairly important aquifer in areas where there are no other aquifers. For example, the Denver Basin aquifers are not present. The thicker Ogallala sequence in eastern Colorado is not present, where people would normally get their water and would be a much less expensive choice for water supply. It's going to be more important in this area of northeastern Colorado where those aquifers are not present.
Any questions?
I have a couple.
Commissioner Hawkins?
What kind of permeability are you think exists there? I mean, you know it's silty, so it's low, but.
Right. We're in the midst of one group has gotten sidewall cores in this aquifer to try to determine that. And I don't have those numbers, but I'm trying to, I did hear those recently, and I think they're in the 10 to the -4, -5 range for permeabilities in feet per day.
And then what kind of TDS is the quality of the water?
Again, anecdotal, I think that we've heard less than 3,000 milligrams per liter. So it's good water.
Other questions?
Thank you.
Thank you, commissioners. Just wanted to keep you apprised of the situation. And thank you, Division of Water Resources.
Thank you, gentlemen, very much.
Oh, I need to make one other comment to make sure you realize that we will be engaging with the operators one more time. I want to reaffirm that.
And now, without further ado,
Mr.
webpage.
Chris Eisinger, please.
So good morning. I'll try and keep this sort of brief since I realize we're running on a tight schedule. So I'm going to show...
Introduce yourself for the listening audience.
Sure. This is Chris Eisinger. I am a senior research scientist here at the Oil and Gas Commission. I've been here for about just under 2 years now. So I am a geologist, not a web developer, and have been tasked with doing this. So I'm going to show just a quick couple slides here. Let's see. It's useful to do this as an analogy of a new home for our website. And the first thing I'll say is that the current home we have is perfectly acceptable. It's adequate. It works well. A lot of people are very familiar with it, including our staff and regular users on the outside. But we need to update it. Obviously, our agency has grown since I guess almost 15 years since the original site was first created. And so that is what I've been charged with doing. And there's sort of three main areas that we've been looking at trying to improve with the website. The first two are pretty standard with redoing a website, which is the design and curb appeal. We want it to look nice and modern. We need to accommodate everybody, so we need more space for it. And the materials that we're using for a new website, the code and whatnot are newer and better for growing into the future. But above all these, we want to maintain the function over the form, and we want to improve the ease of use for users and the accessibility of it. So that's kind of what we've been guided by. And initially last year, we got an external web developer to give us sort of the foundation and framing for our website, but it fell upon us internally to do all the finishing work ourselves, and that is what we've been working on for the last 3 to 4 months quite intensively. And I would like to acknowledge Jane Stanzik, Dave Coleman, who've worked on the content, and then Ken Robertson, who has helped with the back end of all this. So thanks to them very much. The last thing I'll do before demoing it is just make the point that this is not just a lipstick on the pig. That's what I keep saying to people. That's all it is. But really, it is much more than that, and we hope that it will come off that way. Thanks.
I never had to move my head.
So this is what our new website looks like. I'll just focus on a couple things. Just basic form. We've reorganized our categories for our menu structure to hopefully be more simple and clear, with groupings that are more intuitive for people to find things. I will emphasize that all the content is pretty much exactly the same as it has been previously, with the exception of trying to clean up the house a little bit in terms of the policies and other documentation that's a bit outdated. I'll comment that a lot of the information's on here is database driven, so it's being derived dynamically. As we update a database, it then populates things like the news notice and a bunch of other things dynamically, which is a useful tool for management of the data on the website. We are trying to make things a little bit more accessible for all our users, more direct. So for example, a new visitors page that provides people who are not familiar with the information on the site, how can they find things quickly. I think based on some of the comments and feedback we received, we want to expand this into what we call public portal that will allow the public to be able to find things more efficiently and effectively and be more useful to them. So that's one of the things we hope to improve. Another thing that we're doing that was started a couple months ago is operator guidance. We're trying to provide operators with direct information related to revisions to guidance documents and have the most updated information there. So that's another content-driven thing that's being improved. There are several things on here that are hopefully improvements in just usability. An example would be we have on a lot of pages search capabilities that are improved. There's a basic search here, so if you wanted to find things, rules related to wildlife, you can just type in that word and it should limit your results to things like that. And like I said, this is available on a lot of the pages from which we've got lots of content. Additionally, when we go live with the site here towards the end of the month, we will have another persistent search capability in the upper right here that's through Google, and it will actually search the content of the documents as well as just the titles, and so you'll be able to find things that are in the documents more effectively and quickly, we hope. The last thing I guess I'll point out for people here, the hearings information, we've tried to clean this up. Again, it's the same information, but hopefully it's clear and easy to find. On the home page, we have the upcoming hearings listed, and you can find the docket and agenda. As soon as they're posted, they appear there for people to access. Tools that people are familiar with using, the database search tools, they're currently the same as they were previously. This is something going forward. We plan to update these where necessary to allow people more capabilities. But for the time being, this is something that will be familiar to our users as it was previously. So with that, I'll stop there. And there's a lot of material here. I could go on for many more minutes about what's here, but I think that gives you a sense and flavor for what we're looking at now. So thank you for your time.
I suppose you would entertain a question or two. Should we have any?
Absolutely. Yes, sure.
Any questions, Commissioner Benton?
I just wanted to say thank you for doing that, and I'm glad that it was a geologist and not an engineer who designed this. It'd be a lot easier to use.
I hope so. Although the lawyers might not think so.
Okay. Director, any?
Thanks to Chris.
And I welcome comments from any of the commissioners, of course, and any of the public. We're just going into public beta right now, and we'll take feedback seriously and try to incorporate it where it's reasonable in the next 2 weeks or so.
Target date to go online?
I would say by the end of this month, we will switch the switch, so the outside will be using this. And currently, our internal staff has started to use it. And with anything new, there's some resistance, and people need to find things, and they struggle with that a little bit. But for the most part, I think the response we've gotten has been good.
Very well. Thank you very much. Appreciate your efforts. And that
Yeah, I would just reiterate that we have gotten, I think, very positive feedback generally so far, and some good specific feedback from those that we've pushed it out to and asked for their comments. We invite that from everybody once it is up and running. There is also a suggestion box on there. So we look forward to reading the suggestions. Thanks.
Thank you.
Several years ago, when I first came on the commission, or actually prior to that, in going to various meetings, folks from many different states told me this was the best oil and gas website in the nation. So you're gonna do them one better.
Yeah, I've heard that true, and it's mostly because of the data we have available that I think people are most impressed with, and we'll continue that and hope to grow that as well.
Good. We'll stay ahead of the curve. Okay, Director, anything else from
That
your...
concludes my report, Mr. Chairman, and I'm happy to answer questions.
Commissioner Walk, you got him as being present.
Yes.
Thank you, Commissioner. Commissioner comments? Do any of you, I don't know why we have a special section, because you just comment whenever you want to anyway. Commissioner Allward.
Thank you, Mr. Chair. I wanted to point out that in the staff report, one thing that was noted in the outreach was that the field inspection unit attended the Society for Ecological Restoration workshop and high altitude restoration workshop in Fort Collins in the first half of March. And our Denise R. gave a presentation, an overview of oil and gas reclamation, which I thought was very well done. And it was a great, I had a good time meeting with the reclamation, the field inspectors. We've got a good group they all seem to have pretty good heads on their shoulders. So I think we should have some confidence and be pleased with what's going on with the reclamation group. And I wanted to point out, if anyone is planning on attending the Energy and Environment Symposium in Rifle, that on the second day there will be an invited talk from Colorado Mesa University on the benefits of good ecological restoration, that you wouldn't want to miss that.
Thank you.
Nor the panel being given by Director Lepore and myself.
Especially the part given by Dr. Walk.
Are there any other advertisements? Okay, thank you. Further commissioner comments? Hearing none. Audience comments, Ms. Murphy.
Yes, Chair, I have 3 people signed up. I would suggest a time limit at your discretion, and I can call each individual up at, starting with the beginning, and the first is Amanda Harper. Do you want a time limit, Chair?
I think we should, 3 to 5 minutes ought to be sufficient for this, if that will work.
This is for you.
Well,
I don't know how to get it to you.
if you'll hand it to Ms. Murphy, she'll
Thank you.
distribute it.
Okay. I would like everyone to have a copy, but I couldn't do that. That's okay. It'll be fine for Mr. Yu. Commissioner Compton.
Okay, if you'll introduce yourself for the listening public.
Yeah. My name is Amanda Harper, and I'm here, this is the 3rd time I've come to this hearing. And I'm here because the basic situation at my home is that they have 2, Encana has 2 large industrial sites coming into our neighborhood, according to them, and the COGCC has put, I don't know how it's happened, but one of the sets of 12 wells is on hold, and the other one, and it might be because of Boulder County trying to work out with Weld County fines for the County Road 1 that borders, because we're Boulder-Weld County border. And then the other one that just came into the queue, the Regnier 12 wells. So the first is 12 Rasmussen wells, and now there's 12 Regnier wells that are all in about a 3/4 square mile area. The 12 wells that were originally, they're on hold right now, are in front of our house, and including a facility that's, I don't know how big, 5 acres plus all the compacted ground that goes around that. And it's going to diminish our view, and it's going to diminish our air quality. And we have, as a group, put together, partly we put together a bunch of comments into the Rasmussen, and now we're going to put some into the Regnier. But I just want to let you know that we are too late. I'm hoping that there will be some comprehensive planning somewhere along this road, but we are probably not going to get that because everything's kind of happening. You know, the price of oil is the only thing saving us probably right now. But I just want to let you know that we will not be able to live in our home if either of these sites go through as proposed. We will have to move. I feel that the safety of my child's in jeopardy. I've been a farmer there. I was a farmer there, and feel like I can't buy my chickens this year because I don't know if we're even going to be there.
Okay, thank you very much for your comments. We'll be sure that the staff is aware of those, although you possibly already informed them.
Oh, yeah.
Well, we'll re-inform them. Thank you very much, Ms. Harper.
Next up, Chair, is Lauren Bushong, or I apologize for any pronunciation issues.
Good morning, Commission. My name is Lauren Bushong. I'm a student attorney at the Environmental Law Clinic at the University of Denver.
Excuse me.
Yes.
You are a student attorney.
I'm a student attorney, yes.
What's that mean?
It's I'm a 2L, so I'm a second-year law student, but I am participating in the Environmental Law Clinic, which is a practical situation where we have our own clients, we have real cases, and we are supervised by licensed attorneys.
Thank you.
Yes, of course. I'm here today to speak on behalf of the Sierra Club and about the findings into our study into Form 2As and oil and gas policies throughout the state. In the fall, a team of clinic students reviewed over 1,500 oil and gas permits and found that 181 permits approved after August 1st, 2013 lacked legally required information. This information included the number of wells, the distance from building units, and other location details. These error-filled permits were especially concerning because they were for wells nearest to residents in either buffer or exception zones. Not only do these permits not provide the correct and necessary information to the general public, but they also do not allow the Commission to make fully informed decisions when choosing to approve or disapprove permits. Operators who submit incomplete and erroneous forms fail to provide information that can protect the health and safety of residents. The Commission should reject forms that fail to include all required information. It is the duty of the Commission, as regulators, to ensure completeness of permits, especially for the wells closest to residents. The public cannot be expected to make meaningful comments about oil and gas development in their communities if they are not provided with the correct and necessary information. Another limiting factor to public participation is the failure of all residents in a buffer or exception zone to be notified of the oil and gas development around them. Currently, only building and surface owners are notified, not residents, occupants, or tenants. The failure to notify non-owners is a failure to alert those whose health and environment is going to be directly affected by the development. It limits the knowledge of those nearest to the development and hampers their ability to participate in public commenting. The Commission can remedy this issue and continue to protect the health and safety of Coloradans regarding oil and gas development. Finally, the Commission's website is currently functionally unavailable to laypersons and ultimately discourages public participation. And I've seen from the new website, it looks quite advanced and seems to be a good adjustment because we consider the website to be a public forum that the public can easily gain insight into oil and gas development in their neighborhoods and empower the public and impacted communities to be able to make meaningful comment about the development around them. While the plans to revise the website currently, it does not currently serve the public to benefit them and their knowledge. The Sierra Club is hopeful, though, that changes to the website will embrace the need for better transparency and public activity in the oil and gas development across the state. I raise these concerns to draw attention to systemic problems that limit public knowledge and participation. The lack of meaningful public comment only degrades the Commission's approval process and undermines public confidence. Further, if the Commission approves permits based on inaccurate or incomplete information, then regulators are not being fully informed in their approval process. These inadequacies keep the Commission from carrying out the purpose of their enabling legislation to protect the health and safety of the general public. Thank you.
Thank you, Ms. Bushong. We appreciate your engagement and your involvement in this. It's always helpful, I think, to have a third set of eyes. I think very helpful to us. If I would encourage your organization, your group of folks to come here and meet with our staff and let them show you how they go about the process, and maybe you can offer some improvements there as well. Or in fact, if you want, I'm going to speak, I'll probably say something I shouldn't, Director, but if in fact they wanted to have a more formal presentation before this commission, I would assume we could set aside a time at a future hearing.
We could certainly do that, Mr. Chairman, and we have been in communication with the DU Law Clinic. We've tried to set a meeting with them. Staff has spent a considerable amount of time reviewing the report. From my perspective, to be honest, there's very, very little data that supports the report. There is a spreadsheet that they have provided to us, limited detail to the spreadsheet, but we have done the best we can with that to review what they have presented. We would like to meet with the law clinic students. We've made that offer to them. We got a little bit stuck on where to hold that meeting. We'd like to have the meeting here so they can benefit from the tools that we have available to ourselves here. It would involve myself and two of my managers meeting with them. So we'll continue to try to get that set up. I certainly agree with your assessment that third set of eyes can be useful. But we also find, I think, if I'm not mistaken, this, by the way, this is the same report that we emailed this to all of you back in January when they put out the report. The report was put out on January 29th, was sent to all the members of the governor's task force 2 or so business days before the task force was meeting for the last time in a public meeting sort of situation. So we'll try to continue the dialogue with them.
Very well, thank you. I appreciate your presentation. I read 1L by Scott Turow. Was that a fairly good representation of the first year?
I haven't read it actually myself. I didn't want to be too worrisome or scared going into the first day, so I avoided that type.
Well, there's an opportunity for you to write for 2L.
Yes, yeah, okay. I'll put that into my summer plans.
Okay, thank you very much. Did we exceed our time?
She didn't exceed her time.
Oh, I got it. Okay. If the shoe fits, you wear it. Okay.
The last person I have is Kate Hall, Chair.
So welcome back, Ms. Hall.
Thank you. Thank you. I appreciate you giving me an opportunity to do that. Good morning. Thank you for the opportunity to speak with you again today. I'm Kate Hall, a resident of Timnath, Colorado. As you may recall, I spoke at the commission hearing in January regarding dozens of errors and inconsistencies contained within the Peterson Energy applications for a multi-well pad site and production facilities proposed to be located approximately 2,000 feet from Bethke Elementary School in Larimer County, and also of my concerns regarding evidence of systemic issues associated with the current permit review and approval process. Since I spoke with you in January, I've continued to monitor the status of the Peterson applications, as well as numerous other permit applications throughout Colorado. I provided Director Lepore with a memorandum of my findings regarding the Peterson applications on March 20th, of which you've each received a copy today, and in which I addressed significant errors, inconsistencies, and omissions that remained in the Peterson applications even after they had apparently cleared final internal review and awaited imminent approval. I also expressed serious concerns related to the current practice of commission staff members correcting operator-submitted documents, followed by those same staff members auditing and approving their own work product. One thing that I've learned in my professional audit training is that this practice has no place in any agency, particularly within a regulatory agency, as it defeats the purpose of checks and balances. I would like to illustrate the significance of the systemic problems and issues embedded within the current COGCC permit review and approval process by again using the Peterson applications as an example. As you can see, I have Rule 303E on the slide. Per Rule 303E, any Form 2 or 2A, which is submitted without the required attachments, proper signature, or required information, shall not be reviewed or approved. Under this rule, the applicant has no more than 30 days from the date of COGCC's notification of inadequacies to correct or supplement its information to bring its application into compliance. After that deadline, any application lacking full compliance shall be considered withdrawn by rule. The Peterson Form 2A was resubmitted in early December without the requisite pre-application certification letters from both building unit owners located within the buffer zone. On December 8th, commission staff notified Peterson of the missing letters, and a short time later, Peterson submitted a signed waiver for only one of the two building unit owners. Nevertheless, on December 9th, just one day later, the COGCC permitting department deemed the Form 2A complete. The signed waiver for the second building unit owner was not submitted to COGCC by Peterson until April 1st, 2015, 115 days after commission staff notified Peterson of the deficiency, and 12 days after I personally notified the COGCC in writing of its omission. Rule 303 mandated that Peterson 2A was to be withdrawn on January 8th, 2015, the 31st day following COGCC's request for the required documentation, as Peterson had failed to cure the deficiency with the allowed 30-day period. This mandatory withdrawal was not enforced, and as of today, the website reflects the Form 2A remains in process, and staff comments dated just this Friday recommend it for approval. In my memorandum to Director Lepore, I also expressed concerns regarding Peterson's failure to meet the requirements of Rule 303B3 and its subsections, which requires certain information be attached to a submitted Form 2A, including, among other things, a location drawing showing all wells and production facilities. In the resubmitted Form 2A, you can see up there, in their resubmitted one, Peterson omitted any mention of utilizing emission control devices. On February 6th, following questioning from commission staff, Peterson stated they intended to use two 48-inch VOC combustors. Neither the location drawing originally submitted nor the revised one submitted on March 2nd contained the VOC combustors. The one you see up here is their third attempt. The memorandum identified problematic issues regarding the omission of the VOC combustors from the drawing.
Ms. Hall, you're at your time. Chair will defer to you.
May I have?
Take a moment to kind of wrap it up, and that'll be fine.
Okay, thank you. Well, on that note, what I will do, I will move forward. This is the resubmitted revised permit application showing the VOC combustors. They're on a production pad. And this is the same drawing with my overlay demonstrating the safety setback requirements for fired vessels from separators, tanks, and wells. Those two red dots in the yellow circle are the VOC combustors, approximately 10 feet from the closest separator and approximately 40 feet shy of the minimum mandated safety setback. As you can see, the application remains materially deficient, yet commission staff continue to review and correct. I cannot believe the COGCC rules and regulations allow for any discretion in this particular situation. The only action available to Director Lepore is to reject the Peterson applications in their entirety. Mr. Chairman, members of the commission, I respectfully request you consider the seriousness of these application review issues, along with the other issues raised here today, and address what I believe are deficiencies in both the analytical process and the checks and balances phase. Finally, I ask you to consider the need to strictly adhere to your rules and regulations designed to protect public health and environment, and those which were designed to encourage meaningful public participation. Thank you.
Thank you very much, Ms. Hall. Okay, any comments, Director, or additional public comments?
Ms. Hall was the last public commenter, but Director.
Let me respond briefly, Mr. Chairman. So first, I had it on my to-do list all week to get a response to Ms. Hall on her March 20th letter, and I failed, although there's a draft now as of yesterday. But, I want to say that what Ms. Hall has done here has been tremendously helpful for us. She has clearly put a lot of time and effort into this. She has a good professional background as an auditor to do this. In one sense, it's part of the reason that we allow public comment or that we have public comment. She brings a particular expertise, but often members of the public are aware of things that we don't have another avenue, to have come to us. So it's, in part, it's that. We have spent, again, a tremendous amount of time reviewing the discrepancies, real and alleged, that Ms. Hall has identified. And some of those we've shared with you. We shared with you briefly, I think, at the last hearing, some of the things Ms. Stanzik did that would appear to a layperson to be an error of some kind. I think there was one of those had to do with how the site was referenced on one of the documents. I think it was said it was Weld County, or I can't remember. Jane, you might remember the details, but that was the operator's name for their operation. It had nothing to do with where the location was going to be built or anything like that. So it was just something that looked odd to Ms. Hall that had no relevance or meaning to us. I will go on to say that the Peterson applications weren't very good. They really did have a lot of errors and mistakes. And we've had a lot of conversations with Peterson about that, with their consultant about that. But we also, the 303E rule that Ms. Hall cites, we interpret differently. And we have for a long time. And maybe you're a lawyer as well as an auditor. We have a completeness determination, a 10-day review. That's what 303E refers to. It is not a detailed review. It has never been intended to be or applied as such. It's a very high level review. Is the information, the core information, present? If it's not, we ask that they provide that within 30 days. In this case, the form passed completeness review. Now, I don't have the answer. Haven't talked to staff at this level of detail about whether that was an error. a lot of things pass completeness review, and then we spend the ensuing 30, 60, 90 days, I cited you the statistic, about 43 days on average, to track down and pin down and get the information that we have to be accurate and complete. That's always been our process. And there is no 30-day clock ticking at that time, right? We identify an issue. We ask the operator, you know, if we're correct that something seems amiss, how is that going to be corrected? No 30-day clock ticking. I also don't particularly, and I haven't spoken directly to Ms. Hall, I don't quite see the same, I wouldn't characterize it the way she does when she says we make corrections and then approve our own corrections. I don't think that's a fair characterization. If we see something that we feel doesn't line up, we communicate with the operator, we try to get the right information, they provide the right information, we move forward with the application. This is this lengthy process where we have the permit in process. The Peterson application has been in process for 125 days. Most of that has been to work through issues identified by Ms. Hall, issues identified by staff, to get the Peterson application to where it should be. And I think we're close, and I think Mr. Dronlow, I'll give you the opportunity to add any details here if you want to. I will say on the fired vessel issue, here again, another maybe simple misunderstanding for a layperson, but the emission combustion units are a fired vessel. Ms. Hall is correct. The separators in this case are also fired vessels. So there's two fired vessels 10 feet apart. That's not a violation of our rules. So that one's just not quite right as a violation. I'll stop there. We did, again, when Ms. Hall was here, I think the first time she and Jane Stanzik spent about an hour and a half together going through some of these issues. Her March 20th letter is very thorough. We've been through all of those issues. And there were some, please don't misunderstand. I think there were 3 or 4 at least in this letter that we did follow up with Peterson on. Ms. Hall cited previously our rejection policy. Sort of good to know somebody's paying attention. That rejection policy was brand new at that time, the first time we've ever instituted it. So we have made a determination at the staff level that there's got to be, and we've talked about this over the last couple of meetings, from operators, a standard that they need to get over to have the permit in here to begin with. And we have tried to identify that floor now. And I think, frankly, as a result of this, and this is, in fact, in my draft response to Ms. Hall, we'll continue to raise that bar a little bit. I think it's very, very debatable whether the Peterson application should have passed muster in the first instance. The fact that we've had to spend 4 months and Ms. Hall has spent a lot of her time to get it where it needs to be is really not acceptable, right? And again, you go out and hire a third-party contractor, I would think that for your money, you would want an application that kind of sailed through the process. I've also talked to staff, we've talked internally. There is an emphasis on timely review, right? Our statute says we are obligated by statute to provide a timely and efficient review process for the permits. That's what the General Assembly has told us. They don't want this to be a 125-day process. But the applications are more complicated than ever, right? The setback, all those 1,000 feet, 500 feet. Is there a high occupancy building unit? Are we in an urban mitigation area? Those add complexity to the application process, to the review process. So we've talked internally about de-emphasizing the speed and emphasizing the quality review. If it takes a little longer, let's get it right. So I'll stop there. Greg, do you want to add anything, just details? Okay, all right. Happy to try to respond to questions.
Any questions, commissioners? Commissioner Howard.
Thank you, Mr. Chair. Thank you, Ms. Hall, for coming before us. I find this all kind of embarrassing. And I think clearly we need to do something to get better applications before us. And it reminds me of my PhD advisor, who when you'd hand him a chapter of your dissertation and draft, he'd hold it in his hand and wave it in front of you and say, is this the best you can do? And if you said no, he'd give it back to you and say, well, I'm not going to read this. And it wasn't until you said, yes, this is the best I can do. So maybe we need a checkoff on there, something where they state, yes, this is our best work. And before it arrives in front of the staff, something that says, you know, that they're as complete as they can get. And so it's not wasting staff time on partial applications.
May I respond quickly, Mr. Chairman?
You may.
Mr. Albright, I think what will raise the level of thorough and accurate applications is when we reject a few more of them. And needless to say, we will try to communicate our expectations clearly to the regulated community. It's not a game of gotcha. But there does need to be a standard established, a clear line. And if you can't meet that, then you get to start over. At the same time, I think it's important that everybody realize how much information is in one of these applications. And I don't think it's a zero error sort of standard. One of the things that we found troubling about the DU report in particular is they claim to have identified, quote, major errors, but they don't define that term in any way. What constitutes a major error? I can think of things that I would put in that category and many, many things that I would not, and many things that I don't think should lead to the rejection of an application. So I think there is room in the process for back and forth between ourselves and the operators. Again, we've been doing it that way for, I don't know, probably 60 years. But yeah, operators need to put as much emphasis on this part of the regulatory compliance as they do on other parts.
Okay, thank you very much. Thank you, Ms. Hall.
Mr. Chairman, may I respond briefly?
Briefly.
Thank you. I just want to touch on two key points that Director Lepore raised. One being making corrections and auditing the internal work. I have numerous different documents between staff and operators discussing, we're going to go ahead and update this information. We found this. If you're okay with it, we'd like to correct it and amend. I have numerous documents showing actual changes being made. And when an operator signs off that this is their report and the staff signs off that they are an independent third-party reviewer, you can't have any overlap. Whether it appears immaterial or not, you have to have that segregation. The other part in regard to the safety setbacks, he's correct. I very well may misunderstand, but I spoke with industry experts before coming forward with this. And when it discusses the fired vessel, including heater treater, 50 feet away from a separator, plain language says 50 feet away. And I pushed a little bit further. I said, what about a heated one? And they said, the risk is that the pressure release valve, in the event of buildup, you essentially run the risk of a combustion outside of your combustion chamber and run the risk of a major explosion within your pad or your production facility. And the expert that I showed the plat to said, even at 50 feet, he felt that in his opinion, was probably not even far enough, but that this 10 foot, 15 foot away was extremely risky, particularly given the proximity to the elementary school. And I'm just asking that the commission adhere to the rules and insist that the staff adhere to the rules, because 303 has different parts. E dictates what happens in that initial 10 days which is when they notified of missing information, and also the same day that the mayor of Timnath, who is leasing minerals to the operator and in leasing them out for this project, sent a letter to Director Lepore asking about the inadequacies and apparent problems and incorrect information within the application, asked about it and asked if he could certify that that had been taken care of. And all of these changes that came about, the VOC combustors, all of those additions came well after public comment had closed. The public never had an opportunity to talk about the VOC combustors, to talk about the real distances. I feel like when that is taking place and public comment is closed well ahead of time, you can't have meaningful public participation. And I guess I'm still at a loss, because if an application with this many errors and still 12 or 13 errors on its face today is not one that you would set an example with and show the operators that they have to get this correct. It's not up to staff and taxpayer dollars to put in applications. It's up to the operator to get them right, and it's in their best interest. And they'll learn. If they start getting rejections, they'll start getting it right. And I just ask that the commission see how that goes.
Okay, thank you very much. We appreciate your involvement. I think, well, I'm convinced that it will, all of your efforts will result in a better process. Just has taken us some time to develop that. So thank you again very much.
Mr. Chair.
Commissioner Allward?
One real quick comment. Again, thank you again, and thank you for some clarifications. What I was just wondering is if there's a method that the staff might be able to work out so that when members of the public have presentations for us and want to give us documents, if there's a way to get them to us electronically. Because I'll misplace some of these paper documents, but I've got a file structure now to keep all the electronic ones in one place. So it might be nice if that's possible to work out a way, maybe with a new web page, but how somebody could get the documents to us electronically and shared with us, even the morning of.
We'll work on it.
Thank you again, Ms. Hall.
Thank you.
Okay, Ms. Murphy, we'll move to the consent agenda.
I believe so. I would like to note that Commissioner Craig joined us during the middle of Ms. Hall's comment, and we've got it. And
duly noted. Welcome.
So, Chair, I would ask if there are any conflicts that would require recusal by any of the commissioners. And then it's at your discretion to take these up as a group or individually as you see fit.
Okay, commissioners, do you have any conflicts to declare? You want to recuse yourself on any items? If not, I would entertain the possibility of considering the consent agenda. Maybe we'll pull off the enforcement matters and take that separately. But Group A through Group L at this time.
So moved.
Second.
Motion to approve and a second. Any discussion? Hearing none. Those in favor indicate by saying aye.
Aye.
Opposed, same sign. The consent agenda A, Group A through L stands approved. Now the enforcement matters, Group A, of which there are 4.
Move to approve.
Mr. Chair, if I may.
Okay, we have a motion to approve.
Second.
And we have a second. So there's some discussion. Commissioner Spielman.
Thank you, Mr. Chair. In an abundance of caution, I would ask that we pull Great Western out from Group A. I don't know anything about this matter other than what the staff has provided us. There are folks at my 3,000 lawyer law firm that assist Great Western in other parts of the country to avoid any inadvertent or even appearance of impropriety. I really just don't know if my law firm's involved in that matter, and so to be abundantly clear, I'd like to recuse myself from consideration of the commission's determinations.
Okay, we can do that.
Thank you.
So we'll consider will source, benchmark, and genesis initially.
Thank you, Mr. Chairman.
What is your pleasure on those three?
I'll move to approve.
We have a motion to, well, let's see, we did already have a motion, didn't
Yeah.
we? But we're going to amend that.
Accept the amendment.
Okay,
I'll second that.
thank you very much. Those in favor of that amendment of pulling those off separately indicate by saying aye.
Aye.
Opposed, same sign, so they're separated. Now then, a motion to approve the enforcement matters on will, source, benchmark, and genesis.
So moved.
Second?
Have a motion and a second. Any discussion? Hearing none. Those in favor indicate by saying aye.
Aye.
Opposed, same sign. So those three are approved. Now let's consider Great Western. Is there a motion for Great Western?
So moved.
We have a motion to approve the enforcement matter against Great Western. Is there a second?
Second.
Is there any further discussion? Here, Commissioner Benton.
So the record will reflect Commissioner Spielman has recused himself from this.
Duly noted. Those in favor of approving this matter indicate by saying aye.
Aye.
Opposed, same sign. So that matter stands approved. We are going to proceed then to the general hearing matters. I suspect it would be appropriate, Ms. Murphy, for us to take a 10-minute break.
Absolutely.
That's okay with
Yes.
you, and then we'll reconvene and take up the general hearing matters. I'm sure it will take Ms. Jost at least 10 minutes to get
I didn't know whether you wanted to try to enter a timeline and see if she objects to our timeline.
We decided we were.
And there's where we're thinking in those terms to determine. Yes. Yeah, that's right. And we have to worry about that.
I think the commissioners. They get started starting to get lost in dates.
Okay, Ms. Murphy, whenever you're ready, if you will introduce the subject.
I would be happy. I'd like to 150100032. Jill Durancy is the hearing officer for this matter. The applicant is Verdad Oil and Gas, represented by Jamie Jost and Joe Evers. Protestant is Renegade Oil and Gas, represented by Scott Campbell. This is a request for an order to pool all interests in an approximate 320-acre wellbore spacing unit established for the east half of Section 28, Township 1 North, Range 65 West, 6th Prime Meridian, for the development and operation of the Niobrara Formation. A hearing officer recommendation was included in the portfolio. I see that the parties are here, and I would turn it over to Mr. Durancy.
Thank you. Jill Durancy, hearing officer. As Ms. Murphy stated, Verdad filed an application to pool all interests in an approximate 320-acre drilling and spacing unit. Renegade protested the application, alleging Verdad's purpose in drilling the well was for lease preservation purposes and not to drill an economic well, knowing that the well would not produce. Accordingly, Renegade stated that it would not receive its just and equitable share of production from the well. There were two pre-hearing conferences held, one on February 4th, 2015, one on March 30th, 2015. The parties have stipulated to witness qualifications in this matter. A hearing officer recommendation was prepared as stated and submitted in the portfolio for your consideration. There are a number of undisputed facts in this case. Renegade was provided with the well proposal with an AFE with the estimated costs in November 2014. Renegade did not object to the well proposal within the 30-day period set forth in Commission Rule 318AE5B. After the expiration of the 30-day period, the director administratively approved the application for permit to drill, creating the wellbore spacing unit. The Young 01N-65W 28-8N well was drilled in January 2015. The well is currently shut in and has been shut in since mid-January after the flowback operations concluded in mid-January. Verdad has provided an AFE with the actual costs of the well to Renegade. Verdad provided the information as required under Commission Rule 530 to Renegade at least 35 days prior to the date of the hearing. The parties here have been allocated 30 minutes each for their cases in chief, and there's also been allocated 30 minutes for commissioner deliberations. Thank you.
Good morning.
Good morning, Ms. Jost.
Hey, Jamie Jost of Burleson LLP, here today representing Verdad Oil and Gas Corporation. And I would just like to start with a very brief opening statement. Again, my name is Jamie Jost of Burleson LLP. Oh, sorry. Let me make sure I get this right. All right. On behalf of Verdad Oil and Gas Corporation. The matter in front of you today is a very straightforward pooling application for the Young 01N65W28-8N well, a designated 318AE horizontal wellbore spacing unit. The application was properly filed and amended to correct the well name, and the stipulated facts you're going to hear today are just as straightforward. Verdad properly sent and Renegade received the Rule 318AE well proposal for the Young well. Renegade did not object to the Young well proposal on the basis of waste, correlative rights, or that Verdad was not an owner in the unit. The COGCC approved the APD on October 31st, 2014. Verdad then properly sent Renegade the required Rule 530 election letter to participate in AFE, fully in compliance with Rule 530A and B. Renegade did not respond or elect to participate within the required 35 days based on prior precedent of the COGCC that deems them a non-consenting party, as well as under the Rules 530B. Renegade specifically expressly stated in its pre-hearing statement that the AFE costs of the well appear to be consistent with similar horizontal wells in the vicinity of the application lands. Renegade is not contesting the cost of the AFE that they received, and they have also received the actual costs of the well to date. I would just like you all to keep in mind as you hear the presentation today that these are stipulated facts, meaning that even Renegade agrees that Verdad has satisfied all of the requirements to allow a pooling order to be entered for the young well. Verdad has complied with the statute 3461-16, and 7. It's also, quote, checked all the boxes for Rule 530A and B, as well as C, to ensure that this pooling application can be approved. So although Renegade has stipulated to the necessary facts to support the approval of the young well pooling, we are still here in front of you. We're still here because Renegade has forced the issue of utilizing the statute's language of just and reasonable to question whether or not the cost recovery penalties can be applied in a modified way, meaning less than the 100% mandated and statutorily allowed by 3461-16, 7. The reason Renegade is still forcing the issue is because it believes that while the interests are pooled, and in effect, which could potentially serve to save some of Renegade's leases, it should not have to incur statutory penalties for Verdad's reasonable development of the well. Further, in its submitted exhibits, Renegade has attempted to capitalize on the downturn in commodity prices to argue that the young well would not be economic. Verdad will present evidence that illustrates that the young well is intended to be economic. It was intended to be economic in November 2014 when we all sat at a very different stage in commodity world. And they will also show and present evidence that it will be economic now, even with the lower commodity prices. And in a case we're all familiar with that occurred between ConocoPhillips and Renegade approximately 2 summers ago, this commission determined that the statute was a mandatory 100% cost recovery application to non-consenting parties. This was very clear. And that the commission could not modify the mandatory penalties and either the numbers associated with the penalties or what those penalties applied to. The penalties applied to what was stated in the statute. We now have the same company, Renegade, going against that very precedent it pushed so hard for 2 years ago that has served to hold up a very straightforward pooling application from approval. Verdad supports the hearing officer's recommendation of approving the young pooling application, as well as the statement that Renegade's approach to this well is to give Renegade a free ride, as that is exactly what Renegade wants. With that, Verdad requests that this commission stick with its precedent, the statute, and the rule by approving the pooling application and also imposing the 100% cost recovery penalties on Renegade's interests in the young well. Thank you.
Excuse me. Campbell, it's your turn.
Yes, sir. Good morning.
Good morning.
Scott Campbell, Polson, O'Dell, and Peterson, LLC, on behalf of Renegade Oil and Gas Company, LLC. With me here today is Ed Ingvey, petroleum engineer and owner and president of Renegade. Mr. Ingvey is going to testify on his conversations with the applicant regarding whether the well was understood or intended to be a commercial well. I also have with me here today J.B. Condell, CFO and Vice President of Land for Renegade. He may or may not be testifying depending on the nature of the land testimony we get out of Verdad. And then finally, Jack McCartney, a certified petroleum engineer, and he's going to talk about reasonable drilling and completion costs, operating costs, and anticipated well production as they relate to the well economics. Renegade respectfully submits that Verdad Oil and Gas Corporation's forced pooling application denies Renegade, 1, the opportunity to produce its just and equitable share of the hydrocarbons, and 2, on terms that are, quote, just and reasonable, terms and conditions that are just and reasonable. That's a quote right out of the statute. Renegade was informed by the applicant that the applicant was knowingly drilling a well that would have, at least at that time, a negative net present value. And we think the evidence is going to more than bear that out, because Mr. McCartney is going to provide you with his testimony demonstrating that the well won't pay out at all. And that's with or without a non-consent penalty. Applicant is drilling this well for lease preservation purposes and or for resource appraisal purposes. It's therefore externalizing its lease preservation and or appraisal risk without any reward to Renegade under the circumstances. And we think it's one thing to reward Verdad for taking the risk of drilling an economic well. In that circumstance, Verdad has everybody's best interests in mind. It's another thing, though, to drill an uneconomic well, which benefits nobody except Verdad, and then force pool, in this case, the majority working interest owners in the wellbore spacing unit, Renegade. Renegade therefore respectfully submits that the force pooling application should be denied. So while you're hearing everybody's testimony, we'd like you to keep a couple concepts in mind. First, a quick summary of the relevant concepts under the Act. The Act declares that it is in the public interest to safeguard, protect, and enforce correlative rights. And that's so that everyone may obtain their just and equitable share of the production. And what's the definition of correlative rights? It means that everybody has an equal opportunity to obtain and produce their just and equitable share. And if you read the Act, that concept is reiterated 6 or 7 times throughout different provisions. When should we be looking at these issues in terms of chronology? The facts here show that the wellbore spacing unit was created. Renegade was afforded the opportunity to participate or not participate in the well. The well was drilled 9 days later, and some 24 days later is the time when Renegade's election period came up. And then, of course, we're at the force pooling hearing. So we've got a circumstance where the well was drilled before the force pooling hearing or application was even filed. So we think the time that you look at these issues is when we're before the commission, because the Act 3460-116 requires that force pooling can only be approved and ordered after a hearing. And it's at that hearing that the commission decides, one, whether or not an opportunity was afforded to produce your just and equitable share, and two, whether or not the terms and conditions of the force pooling are just and equitable. It's the only approach that makes sense when we're looking at circumstances where the well is drilled before the force pooling hearing is held. Excuse me. And I think with that, the balance of our comments will follow in our closing statement in terms of legal analysis, and we're ready to proceed. Thank you.
Okay, thank you. Ms. Murphy, I'd like to reserve about 12 minutes for rebuttal and closing. If you could note that and help me with that. Yeah, thanks. All right, the first witness I'm going to call is Philip Davis.
I think you said we agreed just to stipulate we have absolute experts here and we don't have to.
Can we
Great.
swear everybody who might be a witness here?
Please.
Everyone who might be a witness, pay attention.
Do each of you swear or affirm under penalty of perjury that the testimony you may provide is truthful and accurate?
Thank you.
Great, thank you very much. Mr. Davis, can you please just introduce yourself very briefly and discuss your position at Verdad and how long you've been there?
My name is Philip Davis. I'm currently Vice President of Land of Verdad Oil and Gas, and have been in that position since 2013.
Great, thank you. And can you please provide this commission, because this is one of the first times Verdad has been up in front of the commission here in Colorado, a very brief overview of your operations and development plans within the state of Colorado?
Verdad initiated its development plan of this Niobrara and Codell asset in 2013, and after the subsequent geologic and assessments and regulatory and permitting processes, began drilling in October, I believe, of 2014, and to date has drilled 4 horizontal Niobrara wells. We currently have active horizontal Niobrara and Codell permits for another 30 to plus wells, and have began operations on 5 new wells, and plan to continue to develop and operate so long as we believe it's economically beneficial to our company.
Wonderful, thank you. What I've passed around and would ask to be admitted into evidence, and Mr. Campbell has seen this exhibit, is Exhibit L1. This is this packet in front of you. Philip, what I'd like you to do is just describe this exhibit and explain to the commission what Verdad's leasehold interest is in this 320-acre wellbore spacing unit.
Verdad owns leasehold in the northeast quarter as well as the east half of the southeast quarter. Renegade owns the minerals and a lease in the southeast quarter.
And what is your overall working interests in this unit?
Approximately 48%.
Thank you. And just by way of the last few pages on the exhibit that was handed out, can you please just describe what this is? This is the 511 testimony.
Yes, this is copies of the, just the well plat showing the surface location in the northeast quarter and a southward direction lateral into the southeast quarter.
Great, thank you. And then can you also just describe what the letter and the AFE were? Who were those sent to?
Okay, in November, as stated before, Verdad sent Renegade a election letter as well as the well plat and an AFE with our estimated cost.
Great, thank you. And I would just like to move these into evidence for purposes of supporting the Rule 530 requirements as well as the land exhibits.
No objection.
Okay, thank you. And then the second handout, which would be L2, which Julie, I just marked on yours, is the original. Can you just please describe what this is? This is the clarified well one.
Oh, this is the well location certificate with the planned trajectory of the horizontal.
Exactly. And I would just like to move that into evidence as well for purposes of the record.
Without objection.
Thank you. Okay, Philip, thank you. Just a couple questions because we do have stipulated facts. I'm not going to run through everything, but did Renegade object to the original horizontal well proposal under Rule 318 AE?
No.
Thank you. And then did you receive or did they object within 35 days of the election letter or AFE?
No.
And the well was spud in November of 2014, correct?
Yes.
And is it your understanding that a pooling application can occur either before or after the well is drilled?
Yes.
Thank you. And Mr. Campbell stated in his opening that the well was drilled to hold a lease. Is that correct?
No, it's not.
And what is the earliest day a Verdad lease expires in this unit?
July 2015.
Thank you. And that creates the extent of my direct examination right now. Thank you.
We have an opportunity for cross or whatever that is.
Cross-examination, Mr. Briefly, yes. Mr. Davis, let's go to your land exhibit where you note that Verdad is a 50% working interest owner in the east half of the southeast quarter.
Yes.
And isn't it true that that calculation is based on an oil and gas lease that Verdad took from Jordan, the Jordans as mineral owners?
Yes.
And when did you take that lease?
The original lease offer was sent in November along with an AFE and election letter. It was not signed and recorded until sometime in 2015. I don't have the dates in front of me.
And you're, of course, aware that Renegade has a lease with the Jordans for those same interests that's recorded in front of your lease. Isn't that true?
I'm aware of an expired Renegade lease.
And you're aware that, of course, Renegade disagrees with your opinion that the lease is expired.
That has come to my attention.
No further questions.
Thank you. All right, thanks, folks. All right, I'd like to call Arthur Beetrol up for our next witness.
Morning.
Morning.
So let me
You agreed to be an expert and tell the truth.
Yes, sir. Absolutely.
I'm going to hand these around. Julie. Thank you very much. Scott, here you go. You've already seen these. What's being passed around are the exhibits that were submitted to Renegade prior to the hearing. Renegade has seen these exhibits. So what I would like to do now is, Arthur, can you just please state your name, position, and how long you've been at Verdad?
My name is Arthur Beetrol. I'm the Vice President of Operations with Verdad Oil and Gas Corporation. I've been employed by Verdad since April of 2013.
Thank you. And what is the current status of the Young Well?
The Young Well was drilled and completed and was flowed back for several days in the early part of 2015 and is currently shut in waiting on pipeline.
Great, thank you. And in the midst of all of the pre-hearing conferences, Verdad provided Renegade with the actual cost of the well, correct?
Yes, we did.
Okay, and I'd like to direct the commissioner's attention to the first page of the handout that was just provided to you, which would be Exhibit E1, Engineering 1. And the first page through, and my apologies for not numbering these, through basically this last 4 pages are the run sheets of actual costs. And so
There's 19 pages.
Yeah, that's what we're going to be looking at right now. So, Arthur, when you provided these costs to Renegade, are these the actual costs that were most up to date associated with the Young Well?
They were.
And do you believe that these costs are reasonable for the development of the Young Well?
Yes, they were right in line with our AFE.
And do you recall what the AFE costs were?
Yes, just over $5 million.
Okay, thank you. And can you please state into the record what the actual costs to date are for this well?
$4.97 million, plus or minus.
Thank you. With that, I would at least like to submit this Exhibit E1 into evidence for purposes of making the record.
Without objection.
Thank you. Now, what I'd like you to do, commissioners, if you can, is flip to basically the third to the last page, which looks like a type curve and then an economic projection. And Arthur, what I'm going to ask you to do is walk us through each of these economic projections. And just for purposes of the commissions, the reason these are being presented in such detail is because Renegade has submitted that for uneconomic. We want to make sure you have all of the economics in front of you to state that from Renegade or Verdad's perspective, they are economic. So with that, I would like to have you walk through your economic projections.
Absolutely.
And if you could you please start at the very top with the case and type you're looking at?
So at the top right, you can see our case name, which is to identifying the type curve that we are looking at. All the type curves for each 3 of these runs is the exact same, just for your information. The 415 type curve is based on a 5-year strip pricing effective for beginning of April this year, ultimately. You can see in the third column from the right our investment assumption of $3.8 million and our strip pricings under oil price and gas price in columns 1, 2, 3, 4, 5, and 6, excuse me. Under that run, we can generate a 16.5% rate of return and a 1.6 return on investment undiscounted with a payout of approximately 4 years.
Thank you. Moving on to the next economic projection. Can you please describe that?
The next economic projection is showing you a November of 2014 strip when we sent Renegade the election notice. It shows our assumption based on our capital pricing estimates under our AFE of about $5 million. It has the current strip pricing at that time in columns 5 and 6 for that run. And under that run, we were generating a 23.8 percent internal rate of return and a 1.8 undiscounted return on investment with a payout of approximately 3 years.
Great, thank you. And can you please describe the last economic projection?
The last economic projection is basically going to be showing you a 50 and 4 held flat to life base case kind of stress case look at this project at today's capital pricing of $3.8 million. That base case or stress case shows a rate of return of 13.2% and 1.45 return on investment undiscounted, roughly 4.5 years to pay out.
Great, thank you. Just a couple other questions for you, Arthur. In generalities, because of what we've heard from Renegade, would you proceed with drilling this well knowing that it will be uneconomic?
Absolutely not.
Do you plan on producing the young well at it once you receive the infrastructure for it?
Yes, we do.
And one last question. Have you had any technical meetings about this with Renegade?
We have had a technical discussion with them whereby we, before we started drilling the well, showed them our seismic interpretation of the rock, because we have 3D seismic that we've purchased under this area. We went through a substantial discussion with them, showing them how and where we were going to drill the well, where we were going to land it, and how we were going to complete it. And at that time, Renegade discussed potential financing options with us because they told us they didn't have the money to participate at that time.
Thank you. And based on the economics, the anticipated production, do you believe that when Renegade will receive its just and equitable share from this well?
Yes, we do think it'll pay out, and they will get their equitable share.
Thank you. That's all the questions I have.
And Jamie, so you've got about 2.5 minutes of your unreserved time, and at this time, Renegade, if you'd like to begin your cross.
Campbell,
Mr. Chair, may I?
please.
Mr. Beetrell, let's take a look at your type curves. What's the bases for the type curve you relied on? How far away were your analog wells?
Our analogs were from a 19 well data set, anywhere from 1 mile to 20 miles away along the eastern and southern portion of this basin. We brought those analogs, or we used those analogs based on similar lateral lengths, similar frac jobs or stimulation amounts, and as well as looking at similar petrophysical characteristics by the offset vertical logs that were available to the public at that time.
And did you look at the Kerr-McGee well in section 27, which is immediately adjacent to the east half of section 28?
We did. And we actually culled it out of our type curve based on the fact that it was completed in 20 with 2 million pounds of sand, roughly 350 pounds per lateral foot of suction in that well bore. That is nearly 65 to 70% below the industry standard today.
Now, you referenced a technical meeting with Renegade where you discussed the seismic 3D.
We did.
But when was that meeting?
That was prior to the spud and drilling of the well, sometime in, I can't recall the exact date actually.
You spud the well in November 29th, 2014?
That is correct. It's actually early part of December of 2014 when we actually spud that well.
Your conversation was sometime before then?
It was.
You referenced the flowback. You were relying on flowback. And how much flowback was there again, and over what time?
We flowed the well back for probably about, I'm not going to give you a perfect count, but 15 to 20 days, whereby we had gotten at least 10% of our load back, and we had our water production in line or under the with the capacity of our current plans for our facility at that time to go into one water tank. And so we were trying to get our water rates down enough to stop flowback so that we could go into one water tank at that time.
When you were talking about costs, I believe you stated that the anticipated costs were just over $5 million. What What's the balance over the 5 million?
Our AFE cost, I'd have to look at exactly what our AFE is. Our AFE was for $5,069,000, $249. Sorry, $5,069,249.
And you said you've incurred about 4.97 so far.
That's correct.
But you haven't incurred the anticipated cost yet.
To my knowledge, that's what we've incurred to date. We haven't had our March closing yet, so I don't know what our actual costs are today on top of that, if any.
Yeah, Mr. Beecherel, isn't it true that you have a personal economic interest in the well? Overriding royalty interest or consulting
I'm going to
fees?
object on the basis of relevance. That's irrelevant to this conversation.
We think it goes to credibility, Mr. Chair.
There's been no question of credibility that's come up. I renew my objection.
Credibility is always an issue.
I think we're going to not allow the objection.
To the question of my personal vested interest, I'm a working interest owner in this well, but I have no overriding royalty interest at all. So I'm an investor in the well, yes.
So isn't it true that you're being carried in the well?
No.
I don't know what that means.
I can explain it, or Dr. Craig. It's essentially if it's a carried working interest, then the gentleman backs in at payout, so the parent company will carry his costs, and then he'll back in at payout of the well. So he doesn't have to put any money up front. But I believe he answered no, which implies to me that he's had to write a check just like everybody else.
We're back to credibility. Okay, I understand.
I'd like to just confirm. Can you please re-answer that just for purposes of the record? That you're...
I have a direct working interest in the well. So yes, I am writing checks.
Yes, thank you.
No further questions.
Great, thank you. With that, I would request that all the exhibits we've submitted be accepted into evidence, and I'm going to wrap up our direct at this point. We do, however, reserve the right for rebuttal and any other questions that may come up. Thank you.
So they'll be submitted without objection.
Mr. Chairman,
Mr. Commissioner Benton.
are we allowed to ask questions?
I don't know. We have to ask Julie. I think we get a moment. We get a moment a little later. I know, but
okay.
I think it's really up to the chair, and
you can. Is it important to ask it now, or
It goes to the economics, which haven't been discussed, and I think it can be answered rather quickly.
well, then just ask it.
Okay.
And we'll see how quickly it can be answered.
I'll do my level best, sir. So in the economic projection, I'd like to refer to as the $50, $4 flat. And if you look at the gas price, which is listed there in the middle, it would imply to me that you are adjusting that based on the NGLs you get from the gas. Is that correct?
Yes, sir.
And what BTU content are you assuming, and what was the basis for your assumption?
So we don't have an exact BTU factor on our gas yet. As of yet, we're using offset analogs from non-operated interests that we have. But the offset wells that we have non-operated interest right now are consistently yielding plus $1.50 on an NCF equivalent basis. And that's why we're seeing a positive differential to NYMEX on the gas pricing.
Okay, I have lots of others, but I promised I'd keep it short, so.
Well, you'll have another opportunity. But
yeah.
Okay, we are at.
yes, we're up. Scott, if you want to proceed, you've got about 20 minutes left.
Thank you. Renegade calls Ed Ingvey as its first witness. Mr. Ingvey, please state your name and position at Renegade for the record.
Edward D. Ingvey, would you ask Renegade Oil and Gas, CF, or owner, manager,
Renegade Oil and Gas Company, LLC.
When were you first approached by Verdad about the drilling of the Young well?
Well, we had discussions going back almost a year ago, but the first kind of more active discussions, I think, occurred late summer of 2014.
And when did you first start discussing the economics of the Young well with Verdad?
That probably didn't happen until more along the lines of November-ish, November to December, when oil prices were kind of collapsing.
And can you walk us through those conversations?
I know there was a period there where me and Arthur simultaneously attended a conference out in the west part of Denver with regard to Niobrara horizontal drilling and optimizing. And we had some conversations then, and also going into early December. I questioned as to whether this well would stand its weight under what was happening to oil prices.
How did Mr. Beetrell respond?
Well, there was one specific conversation that I remember, and this was when oil prices were still elevated, but he said he ran some economics at one point in time using a $50 base.
I'm going to object to this on the basis that the pre-hearing order, and my apologies for this, but the pre-hearing order did bar any discussions with respect to potential resolutions or discussions that occurred prior to this. So I want to just register that objections for purposes of this.
Mr. Rancy, can you help me?
Yes, my pre-hearing order specifically excluded any settlement discussions prior to the wellbore spacing unit being established.
Okay.
I would classify where Mr. Ingby is going as part of those resolution potential settlement discussions with respect to this well.
Okay, objection is granted then.
Oh, may I have at least an opportunity to respond to the objection, Mr. Chair?
Yes, sir.
These were not settlement discussions. These were conversations that occurred between the parties about the viability, the economic viability of the well at the time that the well was being proposed. The settlement discussions were, these weren't, I can't go into what the settlement discussions were. All I can tell you, Mr. Chair, is that these were the very conversations that the parties were having at the time when they were trying to sort out what's happening with the well proposal and whether or not the well was going to be an economic well.
Okay, then we're going to let you continue along that line, being very careful to avoid any discussion of settlement, just the issue of whether or not, in your opinion, it was going to be economic. Is that correct? Is that where we're headed?
Yes, it's no different than Mr. Beetrell's testimony about to the extent that Renegade was saying it may need to look into some financing along those same conversations.
Just for purposes of the record, I very well respect your decision, but I mean, for purposes of making the record, it is our position that what he's talking about has been incorporated in our minds as potential settlement resolution discussions from day one on this. So thank you.
Your objection duly noted.
Thank you.
So you may answer the question.
Well, I say, to elaborate, I think I was being pressed as to whether I was going to participate or not, and I said I'm not sure that the well under the current economics is going to make it. It wasn't that fat to begin with. And there was a specific case where he said that he ran economics utilizing a $50 oil price, and at a $50 oil price, the well got a 3% rate of return.
And why is that significant?
Well, as we sit here today, the oil price that we're looking at is probably something in the low 40s. And they chose to drill the well out.
No further questions.
Cross. Don't be cross, just cross.
Oh, I'm not cross. I was just thinking, I don't have any cross-examination questions for you. Okay, let me actually, one question. Yeah. Right. So Mr. Ingve, if you would be doing your own evaluation, do you believe that it is fair and reasonable in the industry to value your CapEx on November's prices versus today's commodity prices?
The CapEx costs, I'm not sure I understand
Your capital expenditures.
Well, to my knowledge, the CapEx costs really haven't changed that much yet.
Yeah. So it's the same question. It is. I mean, do you think it's fair to come in and try to do evaluation based on November versus today?
Pertaining to just capital expenditure costs?
Pertaining to everything with respect to this well.
No, I think the evaluation should be done not in November.
Okay.
Renegade did not have any control as to when the well was being drilled.
And isn't it true that you've seen and you've reviewed Verdad's economics that had costs that showed November as well as today, all of them being in the positive nature in the packet sitting in front of you? Isn't that correct?
In the packet, yes, as presented.
So you would agree that Verdad has done an economic evaluation in November as well as today based on the current commodity prices, correct?
There's a lot of parts to that. They revised their economic runs. These aren't the runs that they were doing in November. Is that what you were?
Did you ever receive any economic runs from Verdad in November?
No, I did not.
Thank you. I have no further questions.
Okay, additional witnesses, Mr. Campbell?
No, thank you, Mr. Chair. Renegade's next witness is Jack McCartney. Mr. McCartney, we've already stipulated to your qualifications as an expert in petroleum engineering, but why don't you just introduce yourself and we'll get started.
I'm Jack A. McCartney. I'm a petroleum consultant. Been consulting a little over 40 years in Colorado.
For purposes of your expert testimony here today, what did you review?
I reviewed the production history of all the horizontal wells drilled within approximately 3 miles of the Young well. I reviewed some operating expenses, actual operating expenses that were presented to Renegade. And I reviewed the economics provided to Renegade, and that was a prior exhibit that Arthur presented. And then ran my own economics and developed my own type curve based on area, closer wells. Basically, it ended up being one well, but closer wells than 19 miles.
And you also reviewed the well cost to date?
Yes. Yes, I have.
And based on your review of those well costs, is there anything absent from those well costs that should have been considered?
Well, it appears that Arthur said that they're, 4.9 plus million, close to $5 million they've expended to date, but they haven't completed the expenses for the tank battery. They're still evidently doing the gas tie-in, and there's no expenses in there for the gas tie-in. There's no tubing that I saw in there, and there's no provisions for lift equipment. And that's about it. And those items could add another $200,000 or $300,000 to the total.
So we're looking at about 5.3 million?
That's probably about where they'll end up on this well, yes.
How does your type curve differ from Verdad's curve?
Well, my type curve, actually, we looked at everything within about 3 miles. There's a lock buoy lease about 2.5 miles to the west-southwest of the Young well. There's 4 Niobrara wells drilled there. They drilled towards the end of last year. And looked at primarily the peak rate in those wells, since they're fairly new. And the peak rates were in the 6,000 barrel per month category, as opposed to the Verdad exhibit, which started at 10,000 barrels per month. Then we looked at the well in section 27, I believe it's called the Rao well, and it's been on for about 3 or 4 years. And it's a diagonally drilled well, so it's not a north-south orientation, so it's got a little longer well bore, but the completion may be not what you might complete a well today, but it actually produced better than the Loch Buoy wells. And it's pretty close to the average, even if we include the Pettinger wells up to the northeast, which are about 3 miles, maybe 3.5 miles away. And so we used the Roe well as our type curve because it had, sufficient production history, and it comes in about 7,000 barrels a day, and our total reserves are not all that much different. We're a little bit lower, but the main difference in the type curve is about the first year's production.
And what pricing did you use for production?
We used strip price, actual NYMEX prices for actual prices for January, February, and then we used the future prices to project on out on oil, and used a differential. I believe it was $9.26, which is really close to what Verdad had used, based on some revenue that I received from Noble on horizontal wells in January of this year. Then we tried to emulate the gas price, at least the gas price used on their mark as their April 15, 2015 strip pricing case, which Arthur discussed first. And because we were not sure how they're going to market the gas, I actually received from Noble quite a bit less gas price, but the gas isn't as important in this case. It's important, but not as important as oil. The other thing I did is I used $5.3 million. Well, it started at $5 million well cost. And then after reviewing the actual well cost and what's been included, what hadn't been, I upped that to $5.3 million. And I noticed on Verdad's cash flow that they're projecting the cost at $3.8 million on their economics on that first case he discussed. And if we had upped that on their own economic cash flow, if we had upped that to $5.3 million, well then the rate of return drops to something just below 4%, and the payout is extended a long time, and it just barely would pay out even on their own economics after 12, 13 years possibly. So that's the main difference, is the use of the type curve that include wells long ways away, and the well costs that are shown in his economics.
So will the well using your analysis pay out?
No, if we use a $5.3 million expected cost on the well, it's not even going to pay out.
And that's without the 100%, 200% risk penalty under the Act if Renegade's force pooled, correct?
That's correct.
No further questions.
Okay, I have a couple cross-examination questions, Mr. McCarthy. What do you have to support your $5.3 million number that you cite from Noble? We've seen no evidence of that. What do you have with that?
From Noble?
Yeah, we've seen no evidence where you come up with your 5.3 other than you just stated there's a conversation with Noble. What do you have to support that?
It came from Verdad, not Noble. It was that 19-page list of expenses they presented to Renegade.
Mm-hmm. Okay. And there are numerous wells in the area surrounding the Young well, correct?
Yes.
Okay. And you only analyzed one horizontal well drilled and completed in 2011, correct?
No, we examined all of them.
But your exhibit submitted, you only submitted the row well, correct?
Well, that's because I could include the lock buoy wells, but that would lower the type curve.
But those
And
were not submitted in your exhibit packet, correct?
No, I don't think, I only presented what we used as far as our analysis, and so we used the offset well in this case because it was a higher quality well and had more productive history than the other wells in the area.
Okay. And did you review the completion methods utilized on the row 13N well?
Well, we realized it was drilled a longer well bore and that it wasn't given as much, in our understanding, it wasn't fracked in the same way you'd frack that well bore today. That's correct.
Okay. And you would agree that in 2015, there are different completion techniques that are utilized, correct?
Yes. And,
Thank you.
Yes.
I have no further questions right now.
So you're going to, what do they call that, redirect?
Redirect, just one question. Mr. McCartney, referring you back to Ms. Jost's questions about why you didn't use the lock buoy wells. You recall that line of questioning?
Yes. Yes, the lock buoy wells, the peak rate on those was lower than the offset well, the row well, and it would only diminish the aspects of what you would expect to be produced from this location if we would have included the lock buoy wells, and they were drilled 2014. So I assume they had similar type completion techniques to what Verdad used on the Young well. So I don't think the completion technique necessarily determines the quality of the well. It's more rock quality than it is completion techniques right here. So I'm comfortable with using that row well as the best estimate of what this well will do.
So using the lock buoy wells actually would have helped our case, and you just provided a more conservative analysis.
That's correct.
No further questions.
You have another witness.
We do not, Mr. Chair.
So are we getting like to that summation part?
Not yet.
Not yet.
Sorry. I am going to have Arthur Beachell also testify as a rebuttal witness to Mr. McCarthy's testimony. We reserved plenty of time. Hopefully we won't take it all and move forward fairly quickly on this. What I'd like to do is go ahead and ask you a couple questions with respect to Mr. McCarthy's exhibits first. So can you please pull those up, Arthur? Okay. What I'd like you to do is walk through your concerns with these exhibits and why Verdad believes they should not be utilized by the COGCC.
Well, we think that, one of the biggest, obviously, concerns with the row well is the vintage nature of the completion. And like I said, it was 350 pounds of proppant per lateral foot, which is, the industry standard now is 1,000 to 1,250 feet per the conference that Mr. Ingve and I went to in December. We chose our wells on, our offset wells that we use for our analogy on our type curve. I was actually trained not to use one well as the type curve, honestly. Use everything you can and you have available to you. And in this basin, we have a tremendous amount of data. We have a tremendous amount of vertical penetrations to define whether the rock is petrophysically analogous to the wells that we were in the areas with which we were drilling. And we actually went that far and looked at SOPH characteristics, hydrocarbon pore volume characteristics on the offset verticals that were existing in the original development of a lot of these newer wells, and compared that and contrasted that to the wells that we actually drilled. So that's how we kind of defined a lot of the wells we used in our type curve, was rock characteristics, or lateral length characteristics, orientation characteristics, and also completion methodology characteristics. We went through those 4 sets of characteristics to define what was a legitimate analogy for our offset type curve wells and defining a mean through them. We actually have that available to you if you'd like to see that as an exhibit of our offset wells and the type curve going through them.
And what we did, these are solely rebuttal exhibits. So here you go, Scott.
No,
These will be allowed as rebuttal exhibits for purposes of rebuttal. You reserve the right to have rebuttal exhibits be submitted.
Okay, Mr. Campbell.
Mr. Chair, I suppose it's one thing to put on a rebuttal case. It's another thing to show up with a host of exhibits after they've had Mr. McCartney's testimony since March, late March. I'm going to object to the use of those particular exhibits. There's no reason why those could not or should not have been disclosed to us prior to now, some 45 minutes into the party's case.
Well, these are truly rebuttal exhibits, and what they are is there's 15 to 20 pages of public documents. They're the scout card data for the 19 wells that Mr. Beetrel said that were analyzed. And so this is what happens when you exchange exhibits on or about the same day. You reserve the right to preserve and present rebuttal exhibits if necessary. We can testify to this without you seeing these exhibits. That's, but the purpose was to show, one, how a type curve should actually be utilized and run, and how Verdad has utilized and analyzed 19 wells. So I obviously leave it up to you, but there's no harm in these exhibits, especially when 100% of the information is public information and allowable under the rules of evidence.
Mr. Campbell has not seen these as yet.
He has not, but this is all information from the COGCC website. This is information that Mr. McCarthy may or may not have already looked at for purposes of when he said, I've analyzed other wells, but I've only presented one for your review.
Mr. Rancia, needs assistance on making some judgment here. Should we allow these additional exhibits, rebuttal exhibits, to be included in the record, or shall we let?
I think that would probably be a question that would be more appropriate for your.
Oh, okay. I'm sorry, but I did not mean to.
I had a question, actually. Were there expert reports back and forth, and were there rebuttal reports? No. If they're truly documents within your own database, you can take administrative notice of your own things at any time. And I don't know if there's sort of a narrative report. If there's a narrative report, I understand that would be inappropriate. But if they're just documents from your database, I think that's very good.
And just to clarify what they are, is there's two type curves that are based on the 20 pages of publicly available information. So the first 2 pages are just type curves. The rest is documentation that's available on the website. This public information is inputted into the type curves. So even though it's here, it's all publicly available that, any engineer and economist can go out and do and put that together.
If I could offer a comment.
Would you please?
I think, the data is available to the public, but I would question that the type curves are someone's interpretation of that data. So I would ask our attorney whether or not that would be a concern.
That is, and that's why I asked, is there sort of a narrative report? The graph is a substitute for a narrative report. I think you can opine on your findings, but the underlying documents, the documents that would obtain from the COGCC website are proper.
And the type curve itself was actually submitted in the exhibits as well. It just was in a different format.
Well, then you can peel it off the front page and point us to where it exists in our materials already.
The type curve is actually at the end of your, at the
Your
end of the
exhibit
property cost statement.
E1.
Your exhibit
Correct.
E1. Yes, correct. Last page.
Yeah, well, it was just more of the utilization though as rebuttal for the analysis.
Okay, then we'll allow you to continue. Go ahead.
Okay. So, Mr. Beetrel, could you please just go ahead and describe why the analysis, continue your evaluation of the analysis?
We're just trying to show you basically the analogies that we use, show you the curve going through the wells that we use as the offsets. That's simply it. It's just a type curve visualization tool showing you the actual curve through the wells we use as the analogies. Some are above it, some are below it. It's right in the middle, basically showing you a mean through the middle. The other thing I'd like to point out is that the lock buoy wells, we're actually interest holders in those wells. And we know due to the production nature of those wells, they've been constrained via choke management. And that's why the peak rate isn't as high as the row well that's offsetting us immediately. They actually have much lower decline rates because of that choke management. Now, Mr. McCartney told you that it would hurt the curve. It may hurt the IP of the curve, but it would actually physically improve the curvature of the curve. And that is a substantial need to know item in your situation.
Thank you. And just one last question. With respect to Mr. McCartney's exhibits, do you believe that those support their case for an economic basis of this well?
I do not.
Thank you.
I'm
No further
sorry,
questions.
I could not hear your entire question.
My apologies. It was basically asking him if, based on the review of Mr. McCartney's exhibits, if he believed that would cause an uneconomic well.
I do not believe that
Thank
they
you.
would cause an uneconomic well.
Thank you. I have nothing further. Thank you.
Cross, Mr. Campbell.
Just your brief indulgence, Mr. Chair, given the nature or the fact that this was all just sprung on us about 5 minutes ago, it would be helpful if we could maybe get an opportunity to review this.
We are indulging briefly.
Maybe a 5-minute break?
Oh, my goodness. You're asking a lot.
I just want one question answered. What we're looking at right here, is this analysis your type curve based upon November data? I mean, is this the work that you did internally before the well was drilled?
Yes, ma'am, it is.
Thank
And so basically there's two different items there. There's looking at capital pricing, how much it costs to drill the well, and the pricing that economic run at that time would cost. It's two different points we're looking at here. I don't think it's fair to burden a well with November capital pricing to drill and complete the well with today's commodity pricing. We're in a risky business here, and the business is based on looking at a direct point in time and what the economics are at that time. Not hindsight is great. Hindsight is great, but we have to look at it from two different time points. One today, at what it would cost to drill and complete the well today, at the pricing of today, and what it would cost to drill and complete the well in November of 2014, and the pricing at November of 2014. There's no mixing of the two. It's not apples to apples. It's apples and oranges.
I have another question. Mr. Matter, I need legal question clarification here. What kind of precedent are we establishing if, because of precipitous price drops, people are now going to start coming in saying, we don't like the decision that was made because the price has dropped on something that you approved beforehand? What kind of precedent are we setting if we're starting to go ahead and look at our decisions with 2020 hindsight and the world has changed?
I think that's an excellent question for your fellow commissioners.
Okay. That was a good one.
So I think that is a really intriguing question, Commissioner Craig, because we certainly had those issues on the Western Slope in the 2008-2009 downturn when royalty owners did not want wells drilled because they weren't going to get much return. They wanted to postpone it, and that was not something we stepped in to tell folks that whether it was appropriate or not. They applied for permits, and we based our decisions on what was presented to us, not what others wanted to have happen.
Well, Mr. Campbell, did we buy you enough time with our bantering?
So Commissioner Craig, while we're buying time, I presume that you'll raise that question again during deliberations.
Yes, I will.
Thank you.
Just a few cross-examination questions, Mr. Chair. Mr. Beetrell?
He's ready.
Mr. Beetrell, so
I'm here.
In terms of your economic analyses, one of those analyses was based on the $5 million well completion cost, drilling costs, et cetera. Isn't that correct?
That's correct.
That was, and your apples to apples comparison was November prices with the $5 million drilling costs, correct?
That is the case that you're looking at where it says 11 to 14 strip. That is a $5 million AF feed cost with November's capital pricing, or sorry, November's strip pricing.
Your other two scenarios use $3.8 million in pricing for the drilling of additional wells in this very same area, correct?
Yes, we are actually AFing and sending election notices to offset lessees and unleased mineral owners in the immediate area based on that capital pricing today.
And in those comparisons, did you use product pricing of today?
Yes, we are using the strip pricing from today. That's correct.
And how do you account for the $1.2 million drop in costs over this 3 or 4 month period?
I've bid out about 50 different vendors to accomplish that. So basically, I've reached out to all the different surface providers, drillers, frackers, chemical companies, water haulers, you name it. I've done it. I've bid out and created a subsequent new AFE ultimately based on today's estimate on what I think it can drill and complete these wells for.
For all of the same cost line items?
Yes, the line items are similar.
Similar or the same? I'll withdraw the question, Mr. Chair.
Sorry, Scott, you left us speechless with that question.
So on your new type curve, did you include the lock buoy wells in the new type curve?
The lock buoy wells are not incorporated in the type curve because they weren't incorporated in the type curve in November. Type curve is the exact same.
Yeah, I mean, wouldn't that be important since those wells are close by?
I would think they would be valid analogies, but I have to go in and incorporate them and add them in.
But you didn't do that. I'll withdraw the question, Mr. Chair. No further questions.
We just have one formal response.
I do wish I had incorporated them honestly because I think they'd improve my economics.
Okay. Thank you.
Okay. Do they have any time left?
Remarkably, they do. Verdad has approximately 8 minutes, and I believe I'm a really good timekeeper, Matt.
All right.
Here.
Thank you. And Renegade, I think you have approximately 7. Let me double check math before you begin your closing, if that's okay.
Okay, we're moving now to closing.
Closing, and I will not take 8 minutes, I promise. We'll continue to move this forward.
Reputation is on the line.
Hey, I like my reputation, so we'll move forward very quickly. I basically, just for closing, have a couple points of reminders. I want to go back and really deal with the unstipulated facts that we're dealing with here. There's been a lot of discussion over economics. There's been a lot of discussions over, discussions that happen between Verdad and Renegade. At the end of the day, all of that comes down to the fact that Verdad absolutely followed the statute and absolutely followed the rule. There was respectfully a poor me argument that was put forth by Renegade that they didn't talk to us before the well was drilled. They did talk to him before the well was drilled. Your rule specifically allows for pooling both before and after a well is drilled. If an operator determines that they want to take the risk to drill the well prior to a pooling, they can do that, and it happens all the time. It happens in this case. And so moving forward, I don't want you to leave with the thought that you don't have the ability to expressly follow your rules and statutes just because this was a determination that was made after the well was drilled. and then utilize that to penalize an operator who is continuing to develop in this commodity price environment. And as we heard prior from Mr. Davis, continuing, they have about 25 to 30 wells permitted in the state, and they have a development plan to continue that. Point two being that I want you to remember that the rule mandates that a party is non-consenting after 35 days. It's a stipulated fact that 35 days passed and there was no election or response. Under your rules, under the statute, that makes Renegade a non-consenting owner and therefore subject to the full 100% penalty of the statute. Point number three is that the position taken by Renegade was that Verdad at some point in time stated that this well was going to be uneconomic. That is absolutely irrelevant for mandates of this, because Renegade did not support its burden by providing evidence that this well would be uneconomic, but Verdad provided 3 type curves and economic projections for you, not only in November 2014, April 2015, and then the 54 analysis as well. Verdad has put a lot of effort and time into drilling this well and conducting an economic analysis on this very straightforward pooling application. And basically the last point really is that, Renegade, while they put forth some information, everything's admitted to here. Everything's stipulated, that the boxes have been checked. To make the order coming out of this commission just and reasonable, it has to be just and reasonable to both parties. In this instance, Verdad has taken all of the necessary steps, complied with the statute, communicated with Renegade. Renegade supported the actual costs. And moving down that road, we don't want to end up with a precedent, to maybe go to Commissioner Craig's question, of setting a precedent that you're penalizing operators for moving forward in a very risky environment just because commodity prices are down and another operator may or may not have the funds to elect to participate, or they just may want to hold this up. So at the end of the day, we would request that the pooling application be approved, that the 100% penalty be applied as a whole to Renegade, and that this commission abide by the prior precedent of allowing this pooling application to approve. Thank you.
Mr. Campbell.
Yes, sir. Thank you. Let's be clear here. The issue is not whether or not Renegade is going to get a free look on this well. It's not asking that it be afforded the opportunity to reverse its election to go non-consent. What it is asking you to do is abide by the terms of the statute, which require that you take up the issue of whether or not forced pooling was, whether or not Renegade at the forced pooling hearing had been afforded a reasonable opportunity to recoup its just and equitable share on terms and conditions that are just and reasonable. You make that determination at the hearing. That phrase has to mean something beyond whether or not the costs were reasonable and whether or not the 100%, 200% penalty was appropriate. And let's not forget the Conoco Renegade matter, where this commission denied the forced pooling application, in part because those were appraisal wells laden with scientific costs. You have the ability sitting here today, and you've exercised that ability in the past to deny a forced pooling application because you found that the terms and conditions under those circumstances were not just and reasonable. So it is incorrect to say that all Verdad has to do is jump through a couple hoops, provide an AFE, which we've conceded was within the realm of reasonableness, and then give us the opportunity to go consent or non-consent, and then forced pooling automatically happens. All that does is vest you with the jurisdiction to then decide whether or not forced pooling is being done on terms and conditions that are just and reasonable. We have a hearing. There's a reason why the Act requires a hearing. Now, you've heard evidence that Mr. McCartney reviewed all of the horizontal wells. He just testified to that within, I think, a 19 to 20 mile area. And he settled on using that particular well as being the best and most representative example of what a type curve should look like in that area. Then applying prices today, he looked at it and determined that the well will not pay out. Let's look at prices today as compared to prices as they existed at the time that Renegade was required to exercise its consent or non-consent election. That the record will reflect, this is all part of your record, that was on December 26, 2014. At that time, prices were about $45 a barrel. And when you look at the economics here, a $45 a barrel at a $5.3 million drilling cost, completion cost, et cetera, is not going to net you a well that's going to pay out. So what is Renegade being presented with? The circumstances here are not one where the drilling party is assuming a risk of drilling a well for the benefit of everybody. That's a different analog, a different world. Instead, what we have is a circumstance where Verdad's lease in the north half was slated to expire in June or July of 2015. You heard Mr. Davis testify to that. Their goal was to prevent the lease from terminating. Maybe a valid goal, but that's not our problem. And why should that problem be externalized such that Renegade has to bear some proportionate burden of that in a circumstance where everybody knows that that well's not going to pay out? So the choice, quote unquote, that Renegade is afforded was to spend $100 to make 80, which nobody would do, or sit back and do nothing and watch its production be drained out of well and receive nothing for it under a 100%, 200% non-consent penalty. So Renegade very firmly believes that under these circumstances where the forest pooling applicant decides to drill the well in the midst of waiting for the consent, non-consent election, and in circumstances where the prices won't support a finding that the well is going to be economic, that they assume that risk that when we show up at the forest pooling hearing, circumstances might have changed. And in this case, they changed, but the ultimate result doesn't change because under either scenario, whether or not we're looking at the December 25 election period or today, the well will not pay out, and Renegade will see no value out of its investment in this area. So respectfully, we request that the commission deny the forest pooling application under these circumstances. One last point to go to Commissioner Craig's question about precedent. I don't know how often you're really going to see this, to be honest. If prices are low enough where the well is not going to return even LOE, lease operating expenses, for purposes of perpetuating the lease past its primary term, nobody's going to drill the well. And in circumstances where we're looking at maybe $60 oil, we'd be having a completely different conversation. I think you're starting to get up into rates of return and at least positive net present value instead of negative net present value at a 3% or a 5% rate of return. So it's only in these very marginal circumstances where the parties are unable to otherwise come to some sort of outside resolution on how this should be resolved that you're going to be facing these kinds of issues. But it's a significant issue. It's relevant, and we think it is something that you should be accounting for and giving consideration to when you're taking into account whether or not the Renegade is being force pooled on terms and conditions that are just and reasonable. So maybe it'll encourage people to force pool first as opposed to doing it after the fact, and you won't see these issues at all. Thank you.
Okay, thank you very much. We're going to close record and deliberate.
Yeah.
Oh, I'm sorry. Absolutely.
And we have a few minutes left for Dad to rebut or close, like finalize their closing statement.
I do. I just have 2 points.
That's something new to me. They get to adjust their closing statement?
Well, additional.
Because they have the burden of proof, they get the last one.
again, 2 points. Mr. Campbell stated that, Mr. Davis testified that the lease expires in June or July of 2015. He did. But he also testified the fact that this well was not drilled to hold that lease. There's point number one, just to keep in your minds as you're deliberating. Point number two is that, regardless of the economic analysis that's been put forth by Mr. McCartney, we have also presented significant and very well supported economic analysis on 3 different types that do support that this well will be economic. One final point is that Mr. Campbell made the statement that he doesn't think you're going to see this type of precedent based on the prices because no one would drill a well. In some instances, in lower commodity prices, you have to drill a well. There are certain reasons in certain instances you may have to do that. I won't run down that road. But what we can't allow is a precedent that operator or working interest owner who's just unhappy at this point in time to come in and prevent that responsible development. Your mission statement says that you are to promote responsible development. What we're presenting to you right here is responsible development. So, and it was on your site that you pulled up on the COGCC webpage. So I just want to make sure that we're all looking at this in the same light, that there is a precedent that will be set with this if arguments are, I guess, approved based upon low commodity prices. Thank you very much.
Okay, Commissioner Denton, you had a question or two?
I do, if I may, but I would defer to Commissioner Craig. Start.
Oh, no, I'll let you start.
So, first question is for Mr. Vettrell, which I think it was pointed out in Mr. McCartney's testimony that facilities and tie-in and so on had not been spent yet. And so I was curious, have you purchased that equipment and have you built that out? Sort of what do you think? They estimate you're at 4.9 today, and they said, oh, you're going to get to 5.3. What's your estimate of total completed well cost, including facilities and tie-in?
We have hooked up and purchased additional equipment. That is a correct statement. It's just not on the February close because we hadn't done it yet, and our counting closes hadn't occurred at that point. But I would estimate that we're going to be in the 5 to 10% over AFE spend. So $5.25 to $5.5 million.
So fairly much in line with what Mr. McCartney said, somewhere in 5.
Yes, sir. I would say that's an accurate statement.
So that's really reasonable. In your economics, it was, it's fairly high level, but it was difficult to see if you had made any adjustments. I'm not sure whose your gas is dedicated to or the type of contract you have, or if you have one, what you did with respect to managing, gathering, transportation, and processing costs, and how you accounted for those.
Those are accounted in the $1.50 differential. So that's where we're seeing that $1.50 positive differential to NYMEX on the gas side. That's including transportation and compression costs.
Yeah, so it's sort of an all-in deal.
Yes, sir. It's on
all this. I still get about $1.50.
Yes, sir. Yes, sir. That's correct. So it is just an MCF equivalent basis, and without a balancing statement, we can't really tell what our true yield and shrinks are on our residue gas and our NGLs. Further, on the oil side, we are going to be trucking our crude, and there's a 9.25 differential on the negative side to get it to Platteville or to Guernsey.
Okay. Yeah, I recognize that. Anecdotally, that's the same number we get for uplift on our western slope gas.
We need a little bit more data here for sure on the crude side.
That would help a bit. I think that covers everything, but one question I had actually for both Mr. McCartney and for Mr. Vettrell is, and it ties back to some of the things that we do, that when we look at developing type curves, we do plot all sorts of different things around lateral length, pounds per foot, length of your stages, whether you do plug and perf, pump and pray, whatever it happens to be. And so I'm curious, for you, how much, did you try to differentiate? It sounds like you just said, okay, I'm going to take these 19, or go out 19, I forget, 20 miles or 19 or 20 wells or whatever that was. And you purposely took the lock buoy wells out because you knew they were choked back. But did you look at completion methodology other than the Kerr-McGee well that you said you tossed out because it's only 350 pounds per foot?
We actually looked at it from even more substantial variable set than just completion methodology. We actually went in and bought extra seismic to look at offset wells and where they were landed in comparison to where we wanted to land them. Land our own wells, excuse me. And then, yes, we absolutely did look at perf and plug versus sliding sleeve at amount of proppant pumped on those wells. And they were, typically within a $3 to $4 million, 3 to 4 million pounds, in the neighborhood of 80 to 100,000 barrels. So we're trying to find absolutely wells that were completed in a similar fashion in those type curve wells that I've provided as the type curve and we actually completed our well very similar to that. We pumped 4 million pounds of sand, 1,000 pounds of proppant per foot. We pumped 90,000 barrels on our wells. So we completed our wells in the exact same fashion that the industry standard is going to today. Okay. And we used geophysical analysis to cull out a couple wells, and we actually found a couple wells that had only been completed with 5 stages or something like that. So because of liner issues or operational issues that the companies were having when they were completing those wells. And so we culled out 3 wells from our data set based on those issues right there.
Okay, so a similar question from Mr. McCartney. Other than proximity to this location and production data, did you take anything else into account in your type curve analysis?
Well, primarily we looked at the closest wells, of course, and this is getting kind of far east in this general area, maybe a little southeast, but we think for sure that you ought to look at the closer the well is, the more relevant it is, in my opinion, and I'm not going to go out and cherry pick wells 20 miles away because because they're complete in a certain way. It's kind of amazing to me that he would not honor the Lock Buoy wells and then use an excuse that, they're choked back. Well, I don't see any reason they'd be significantly choked back in June or July when oil prices were $90 a barrel. I can see where somebody might, do something now if they want because of these oil prices. But it's a situation in my consulting business I've seen where an operator permits a well and it looks like it's not an advantageous time to be drilling a well, and the non-op interest has no choice but to go non-consent and basically forfeits their lease, because these wells aren't going to ever pay the 2-to-1 penalty or the 100%, 200% penalty. So basically those non-operating interests are in a real bind and have no choice, but their lease gets taken from them. So inherently, I think that's a problem with people drilling these expensive wells at these low oil prices. We certainly would prefer if they would defer.
So let me get back to this again. So what I took out of what I heard out of all of that is that we use 2 things: proximity to the existing well and current production in your analysis, and that was it. That's pretty much a yes or a no.
Yes, I can look at some older wells.
Good enough.
That
the Lock Buoy wells, so why were those wells choked back when the well was $100 a barrel? Was it
they were facility constrained?
Facility constrained. Okay. Anecdotally, there's been some evidence with respect to some Williston Basin wells and some other fields that the wells' ultimately recovery does increase if you reduce or if you restrict their initial production. So that was, and you made that side comment, which we won't get into today about.
Well, I mean, we firmly believe in choke management. We think that, by not ripping the wells wide open, that you do preserve conductivity to the wellbore. And so we will absolutely practice choke management practices in our own flowback once we get these wells online.
Last question is for Mr. McCartney. When you talked about the economics, you talked about the basis differential, and you never, that I heard, I'm sorry, maybe I missed it somewhere, but you didn't tell us what gas price you used for base gas price.
Well, we used, tried to emulate what Verdad had in their economics, which is about 1.45 times NYMEX price. And that's pretty close to there. What we didn't hear them say was they accounted for shrinkage. If they're including LPG content, then they shouldn't be forecasted production. They ought to be forecasted natural gas sales, which includes shrinkage. I don't think that's a material thing in their economics. I'm not saying that's, but if you're going to do that, you account for the shrinkage. But you end up about the same place. And I think we got like $2.70 in January from Noble on our horizontal wells.
Thank you.
Excuse me just for a minute. I have
Sure.
some housekeeping.
Please.
Dr. Walk, I understand that you do need to go to an important, like, Department of Health kind of activity. So you got to leave right away, or?
A few minutes.
Okay, don't leave without giving me a chance to, I'm sorry, Commissioner.
Question on my part. Mr. McCartney, question for you. In doing these kind of analyses, I believe the statement was made that this happens all the time in the industry, where you get an AFE and somebody's got to do something somehow and you may not want to do it. So your first pass at economics, generally your economic case with the well costs and whatever you run, and it looks non-economic. But then when you get forced into that analysis, you have to do incremental analysis where you say, okay, am I going to go ahead and go along with this, knowing full well the law states that I have a 200% penalty. So if you're looking at it, when you get the AFE and you have to make a decision, it becomes the incremental case where you're now factoring in the 200% penalty. It's not just the bad economics, it's what follows from that bad economics. The impression I'm getting is what happened when they were faced with an AF, when your client is faced with an AFE and they have to make a decision. I can't find a piece of paper that says, this is a bad idea, no, I'm not going to do it. In the future. At that point in time in November when the AFE came out, where's that piece of paper? Where are the incremental economics saying, for, let's see, it's Renegade, the penalty forces me maybe to go ahead and do the well. I'm missing an analysis here. I'm missing the analysis, I'm missing the incremental that you would face when you have to make the decision when you got an AFE in front of you and you're put in a penalty position. Where are those numbers? I haven't seen those. They're not, I don't see them.
Briefly, you haven't seen those numbers because the prices at that time indicated to Renegade that it was a lose-lose. It wasn't just about the incremental case and what are the impacts of 100%, 200% penalty versus participating, because participating at that point, from Renegade's perspective, was going to yield a negative rate of return, a well that would never pay out.
So they rejected the AFE. Am I missing that rejection?
I believe
in the packet?
We stipulated to those particular facts that the AFE was presented to Renegade part and parcel with the election letter, and Renegade did not object to the reasonableness or unreasonableness of the AFE. It let the 35 days run because it decided that there was nothing it could do at that point. There was no choice really to be made. It was spend $100 to get 80 back, which nobody would knowingly do, right? It's different when that's the outcome, when we were all hoping for, spending $100 and getting 120. We understand that scenario, and we understand that how the act works in that circumstance and why the act should work in that circumstance, like that way in that circumstance. But this was a different set of circumstances. So their choice was spend money and get less money back, or be force pooled at 100%, 200%, and never see any of the production because the well will never pay out. So that's why you don't see that analysis. It's because from Renegade's perspective anyway, it was abundantly clear that nobody should be drilling that well at that time.
But I just heard from somebody that it is industry practice sometimes that there are reasons you got to do stuff, even if you don't want to do them.
We are not contesting the reasons why Verdad drilled its well, but they are reasons unique to Verdad. And the issue here is their lease was going to expire. And in order to perpetuate their lease past the primary term, they needed to drill a well that was capable of producing in paying quantities. That is the common standard under virtually every single oil and gas lease. And a well is capable of producing in paying quantities if it will return 1 penny over lease operating expenses. And that's a function of the market. It's risk allocation as between the lessor and lessee, and it permits the lessee to nonetheless perpetuate the lease in a circumstance where you've drilled a well that won't pay out. And that, again, makes sense to us. But going into it, the goal, in order to force pool, we contest, the drilling party's goal should be to drill an economic well. If you're going to assume the risk and be rewarded for that risk, then let's make sure we're talking about the correct goal, which is to get a well that works for all of us. And if based on the information prior to the day you drill that well, it looks like it's going to be economic, and then you leave a tool in the hole and you can't fish it out, or maybe the geology just isn't what you thought it was going to be, and the well's not very good. Okay, we get that. But going into it.
Let me just stop you there, okay? I disagree with your argument that we're all going in there with a certain set of the same objectives, because we're not. Now, I have spent a lot of time as manager of partnership operations and joint ventures. The fact of the matter is, you really can't know what's in the best interest of your partner. What you have to do is what's in the best interest of your own corporation, because it gets too muddled. And so at that point, you throw something out and say, okay, the clock is ticking, the decision has to be made. And as near as I can figure, that's what happened.
So if you wanted to drill a well at $10 oil, you think it would be appropriate to force pool the parties into it?
I don't know what's happening in the minds of maybe everybody that's involved. And they're on the basis of their incremental economics. It may make economic sense for them. And it is not really up to me to be guessing that. All economics are incremental. They're the difference between the status quo and the status quo plus one well for the specific company. Even the economics here, all economics are incremental. And so as a result, if you're comparing two grossly negative cases, when you're doing incremental, one of them is going to come out positive. But I really can't guess what the other person is doing. All I can do is say, at this point in time, somebody kicked off the clock, and here's the rules.
We respectfully disagree. We think that you have the discretion under the Act, given that the Act says force poolings on terms and conditions that are just and reasonable, to reject this force pooling application. The issue isn't just about what they needed to do, but whether or not Renegade should be force pooled into a well that everybody knew was never going to pay out. And that's our view of the world. We believe the Act is consistent with that argument.
May we have an opportunity to respond as well?
Sure. If you ask them a question, they can.
Okay. Oh, we're kind of
Please
answering
respond.
her question.
Do you agree, concur with their?
So, go ahead.
I just want to be clear on the record. You know, I truly believe it is my fiduciary duty to my partners, both internally and externally, non-operated and operated, in our partnership, the people that we drill for as part of Verdad, that it is my fiduciary duty to be a good steward of their capital. And I did not go into this foolhardily trying to spend their capital in an uneconomic manner. That would open me up to a lawsuit with them, and I'm not interested in doing that. Further, because I am an interest owner in the well, and I want to drill economic wells for myself on top of that.
And just adding to that, just following up on what Scott was saying about, Renegade just sat back and let the 35 days pass. They didn't even object to the initial wellbore proposal under 318A. They let that go. They didn't object. They didn't object to the AFE or election letters. We've stipulated to all of that. So this is where it does become a little bit frustrating for purposes of knowing that Renegade and, you know, its members should understand the rules and understand the statute of how this is and how they're utilized for purposes of 318A wells. We're sitting here because the argument is you have to determine that at hearing. That's in the statute. We don't disagree with that, but you have to be an active player. Renegade's a working interest owner and it operates hundreds of stripper wells here in the state of Colorado. They should know how to do this and not sit back and come to hearing and allow it to go this far. They have to take active steps either way on behalf of their determinations and take accountability for their own actions too. Thank you.
I think they're really short.
Commissioner Allred.
I have a question, just to make sure something's clear, and then a clarification. I'm hearing some mixed statements from Renegade about inferring motivation upon others, in which you've said you're not interested in it, but you repeatedly stated that Verdad was knowingly drilling an uneconomic well. I missed the evidence for that.
It's our view that when you look at the numbers, what other conclusion can you come to? We understand that there's a dispute in terms of what the respective engineers are saying as to what the numbers mean and what the outcome is. But from my client's perspective, anybody who would have looked at those numbers would have known that that well was not going to pay out today and at the time in late December that it was faced with making an election.
Okay. The clarification I want to make sure is that our mission does not say we promote responsible development. If it did, it would be in conflict with the Act. It says we foster responsible development. And I think it's a very important distinction.
Okay, thank you.
Thank you.
Used to say.
Used to
promote.
It did used to say.
Legislature changed.
Okay, any other questions from commissioners to the parties? Well, that being the case, then I think it's okay to close this and deliberate.
I would welcome it.
All right, we have the question before us, basically of whether or not to approve the application for a request for an order to pool. Is that right?
I think I got lost in your statement, so if you could restate it.
Okay, what is our issue then? What are we dealing with?
I think, and Mr. Ansey, please correct me, it's whether to approve Verdad's pooling application.
Yes, that's what okay. Yes, ma'am. We said the same
Perfect.
thing. I
Yeah.
just fumbled a lot. You did a much nicer job.
Mr.
Okay,
Chair.
Gentleman and lady.
I'm going to take a bit of a risk here and move that we approve the pooling.
If we do have a motion, a risky motion.
And you've got a second.
And we have a second to that motion. I'm going to just take a kind of a risk and say, is there any discussion?
I've got some. I don't like the fact that we're gonna have to check oil prices every time we come into this room. I mean, I don't think that's part of our duty. And that's up to the operators. If they want to drill it, let them drill it. The other problem I've got is with the pooling. Maybe in this situation especially, the pooling rules need to be tweaked a little bit. Because I don't think they're quite where they should be in this case. And then I wanted to ask Mr. Matter, is there any kind of a civil remedy in this? I mean, with either direction we go?
I'm sure the parties could figure some potential lawsuit between themselves, but that's not my job. I do want to mention, you know, there's been some discussion about this Renegade and Conoco situation previously from 2 years ago. And, you know, there's sort of a math component of this statute, section 116. And what I did last time was tell you that you really can't tinker with that math. And I don't think Mr. Campbell's asking you to. It seems like he's asking for either yes or no, pull my client or don't. And my advice to you 2 years ago was, the math section of this statute is preceded by shall. So the terms shall be 100% for this, 200% for that. So I think in some situations, a lot of people would agree with maybe this isn't a perfect fit, but I think it is mandatory. The math component of the pooling statute is
I wasn't
mandatory.
suggesting to change that, but maybe somebody should go back and look at it again. Because it's not going to, doesn't work in this situation, in my mind.
Other comments?
Bring up, if I may, Mr. Chair. Some things in which what Renegade has brought up, one of which I think we don't want to go down at all, which is kind of looking at how many times something is mentioned in statute as to whether it's important or not. Because I'll point out I did the word search through the Act, and protection of public health, safety, and welfare is mentioned at least 6 times. Reclamation's mentioned 7 times. And protecting and avoiding adverse impacts to wildlife resources is mentioned 11 times. So if that's how we determine what's important by counting numbers of mentions, we're focusing on the less important things too often. But the other thing that Renegade brought up that I think we should potentially focus on is whether, if there's the potential for externalizing costs onto those that will not share in the benefits, whether that's a practice that COGCC should actively discourage and or penalize. And that might be something to think about in the future.
Now you've left me to have comments. Sorry, I won't blame you. I won't throw you under the bus for that. I mean, those are worth considering. It's what it comes down to is one thing that I think Commissioner Craig brought up is that how do you do the forecasts on the basis of a changing price environment? I mean, as an operator, we've seen 30 to 35% or more reduction in our well costs since November until now. So at the end of the day, you have, I think it goes back to the company made this economic decision. They looked at it and evaluated it and said, we believe that this will be economic for us to do. We should proceed and develop the resource. And, another company says, oh, we don't see it that way. And so they're, the way the rules are set up, they have the opportunity to participate or not, potentially negotiate farm out beforehand, or they may have been able to negotiate more favorable terms and enter the forced pooling. It certainly appears there was some time to do that. But I struggle with it. We're being asked, notionally, if we rule on this, that we're being asked to evaluate economics. I'm not sure if that's what we're supposed to be doing as a commission. I'd leave that maybe with the director. Give us advice on that. We'll throw him under the bus.
A few comments, and I fully support where you're coming from, because I think when the operator proposes a well and evaluates their economic analysis, there's invariably a opinion from other working interest owners. Everybody looks at it their own way. And I think that they're not going to necessarily agree that the well should be drilled or shouldn't be drilled, and there's opportunity to either join or to go non-consent under the operating agreement or to be forced pooled. I think that's what those rules are and opportunities are set up for. So I don't see this as being significantly different than any other forced pooling application.
I mean, you can have 5 different experts do the analysis on this and come up with 5 different type curves.
And whether it's going to cost $5.3 million or $5.1 million, or whether the price is going to be $50 flat, or whether it's going to increase in the future or decrease in the future. And those are all business risks. So I don't view that as something that we need to change for this application.
Any other comments? We do have a motion.
Call the question.
Question has been called. All those in favor of approving this application for pooling indicate by saying aye.
Aye.
Those opposed, same sign. The application stands approved. Okay.
Thank
Ms.
you for your
Murphy.
time.
Chair Compton, as everybody can tell, we're a little bit behind schedule at this point. My proposed path forward, we have 2 enforcement matters this afternoon and a staff presentation. I would suggest that we take a break. The commissioners can grab lunch and then we can hear from the commissioner's lawyer. Jake, do you think you can present in 30 minutes, 45 minutes, 30?
Sure, I can talk quickly.
Yeah. So I would suggest regrouping at 1:10 to 1:15 at your pleasure.
Okay, 1:15. We'll reconvene at 1:15. Now, I'm assuming that we have an executive session, so someone on this commission would have to move to go into executive session for the purpose of.
So moved.
Second, what was the purpose?
For the purposes stated on the agenda.
Yes, sir. The executive session is posted outside. The updated agenda is online, and there are 4 things posted on the agenda. I believe that's adequate.
Okay, so we have a motion and a second to go into executive session for the purpose of receiving from council information on the 4 items that have been posted. All in favor indicate by saying aye.
Aye.
Opposed, same sign. We are in recess for executive session.
See you later.
Ready to crank up again?
I suspect we are. Do we know if Commissioner Spielman will be returning?
I'm sorry.
Commissioner Spielman?
Oh, he'll be here momentarily.
Okay. Well,
But
do we want to give a minute for him to arrive, or shall we go ahead and?
why don't we just go ahead and see if we can get out of executive session?
I think that's a great idea.
During the lunch break, we went into executive session pursuant to the Open Meetings Act, CRS Section 246402 3A2, which allows the board to enter into executive session for conference with an attorney representing the board to discuss disputes that are the subject of pending or imminent court action, or to discuss specific claims or grievances. The topics of today's executive session are listed on the agenda, and no decisions were made.
And that's true. That's exactly what happened.
Mr. Matter, do we need a motion to exit?
We have a motion to come out.
Move to come out of executive session. Second.
Discussion, hearing none. All in favor? Aye.
Aye.
Opposed, same sign. So I think we're out of executive session. I think we could go ahead and commence to begin to get started.
I think that sounds great. We have two enforcement matters that will be heard this afternoon. The first one is docket number 150100177. Jeremy Ferrum, the enforcement officer, will be taking the lead for staff. And Ms. Thomas, could you pronounce your last name for me?
Niebrugge.
So Thomas Niebrugge is here on behalf of Sovereign Operating Company. Jill Durancy was a hearing officer. And at this point, I would turn it over to Jeremy.
The parties agree that the applicant would start and staff would respond, and then if they had any leftover time, they could have a rebuttal. So I'll turn it over to Tom.
Very well.
All right, very well. Thank you very much. My name is Tom Niebrugge. I'm the attorney for Sovereign Operating Company, Sovereign Operating LLC, actually, and attorney number 8418 here in the state of Colorado. And this is an application being filed by Sovereign for relief under Rule 707A related to idle well bonds. We're asking the commission today to consider a plan to address the wells subject to this matter in an orderly fashion. A couple of housekeeping matters here. When the staff filed its objection in this matter, they referred to the applicant as being Sovereign Energy. It is Sovereign Operating, okay? And that is not controversial. Sovereign Operating operates more than 24 wells in Baca County, which have been unproductive for some time. Most are simply shut in. Sovereign Operating has posted a bond with the COGCC in the amount of $60,000. This is an application for Rule 707A exception, not a hearing to determine any violation of the Oil and Gas Act or its regulations. It's simply, in our view, a chance for the commission to approve a plan that we think is worthy and makes sense to deal with the number of shut-in wells that are present on the client's properties in Baca County. We have filed an application with the staff seeking its approval, and the staff has chosen to object to the plan. By appearing in proposing this plan, Sovereign does not admit to any rule violations. The number of wells operated by the applicant and the productive status of those wells are factual matters and are easily ascertained. Rule 707A clearly affords operators such as Sovereign with excess shut-in wells and therefore inadequate financial security to propose a plan to address the situation. We are here to ask your approval of that plan. That's why we're here. We would ask that that portion of the staff's objection wherein they ask that Sovereign post $620,000 within 35 days be stricken. It is our understanding the staff no longer intends to seek that relief today. Now, our presentation today will consist of one witness, Tom Metzger, who's sitting alongside me, and we'll have a number of exhibits as well. Most of these exhibits were attached to a modification of the application for waiver of Rule 707 and a response to the staff objection. We presented that to the commission and filed it last Friday. Hopefully you've had a chance to look at that. So our first witness is Tom Metzger, and he is alongside now. Would you like to swear him in?
Sir, do you swear or affirm that the testimony you're about to provide is truthful and accurate? Thank you.
Thank you. I will hand this to you. You'll be
Director, Commissioners, good afternoon. Thank you. I am Tom Metzger, Chief Operating Officer of Sabra Operating Company, the applicant here. Just a little bit of background. Idle well bonding. Sovereign has been an operator since 1993. I own Sovereign Energy, which was an operator at one point. I own Sovereign Operating Company. Sovereign Energy had bought Colton LLC. All three of those companies at one point had $60,000 bonds in place. We've been an operator since 1993. Ignorance is no excuse, but I was unaware that there was an idle well bond. We're a very small company, and I was unaware that there was an idle well bond requirement in the state of Colorado. In the warning letter that I received September 16th of 2015 was my first knowledge of that. I truthfully was under the impression that filing a plugging bond, a statewide plugging bond, and then using the MIT process as an opportunity to provide the mechanical integrity of wells for environmental protection against aquifers and leaks, etc., along with plugging and abandoning wells was the process that was used. Sovereign operating itself is a contract operator. It operates in Baca County, it operates in Sitting County of Broomfield, and in Weld County. And it generates its revenue through COPUS charges. These three different areas that Sovereign operates in are held under special purpose entities with different ownership. I own an interest in those special purpose entities, but it's a fairly minor interest. But Sovereign's income isn't simply COPUS income. It's also through its oil and gas revenue in these specific special purpose entities. In 2011, Sovereign bought the ownership of these properties is not under Sovereign, but Sovereign took over operations for the special purpose entity in 2011 when we bought this property from Jones Energy out of Austin, Texas, who had bought these from Crusader, who had gone bankrupt in 2008. Jones bought those properties amongst with a lot of other properties. Sovereign took over operating at that point. We were aware that there were shut-in wells on this property. There's 26,000 HBP acres here. Our desire in this area was deeper rights that these leases held and all the producing wells. We intended to buy the property and operate it, enhance all those wells, and to preserve the leasehold for the deeper play that was not, we're still working on it, but hasn't been productive yet. But that was our interest in holding onto this field. Lots of larger companies spin off their low-hanging fruit, and that we looked at that. And truthfully, had I known that there was an idle well bond, that we would have been looking at that point with about 20 wells of about $320,000 that needed to be applied to that right of way, we probably would have chosen a different path. We understand that that's not the case. But we have an operational plan. When we bought the field, we had an operational plan of enhancing wells, and we've continued to do that. Ever since we bought the field, we've reworked 19 wells. We've plugged and abandoned 6 wells. We've done mechanical integrity tests on 19 wells, and we've spent a lot of money here, and we continue to do so. And again, back to the MITs, I think in hindsight, we would have looked at those as, let's spend the money to put those wells back on or plug and abandon them, not to leave them simply idle and have a $20,000 cost associated on a per well basis and not put that money to work. And a little chronology, I guess, before I get into our plan itself. When we got the warning letter in September 16th of 2014, again, it was an eye-opener for me. The staff asked that we come in with a plan to discuss these wells. We got a 30-day extension to do that, and we met on December 5th. 5 staff members. I thought it was a very good meeting. I hadn't been in one like that before. And I came in with the 21 wells, I believe, at that point, and had a request to leave some of them shut in, plug some, and to put some back on production. Staff at that point told me that you really need to get specific with your plan. You need to come back and you can't leave any shut-in wells. You're going to have to be bonded on those. You need to come back with a more formal plan. We did that. And at the time also, it was a 12-month plan to put all these wells back on. Staff said to me that, and it was a very good meeting, but staff said to me that if you need more time to work on these wells, you've got 21 wells in 12 months. If you need more time to work on those wells, you should ask for that. So I came back on December 16th with a filing with the staff about working on wells and taking through May 1st of 2016 was at that point, it was a 16-month plan. I later heard that staff can't acknowledge anything beyond 12 months, that it was my understanding that staff really couldn't sign off on that. So that suggestion that maybe I could ask for more time if needed, had I known that, really would have kept this within a 12-month plan, which is what our current plan is anyway, even though we've added, now it's up to 31 wells, we are within a 12-month plan on this. Again, I was not aware of this idle well bond. Jones Energy has an existing gas compressor out there that's continuing to work on cleanup with the Oil and Gas Commission. They have a posted statewide bond. And on Friday, with our communication through our landman with Jones, we came to find out that Jones did have an idle well bond on these wells, these exact wells, that was released on September 16th, the same day that we were given our warning letter specific to those wells. And in that letter, it said that Sovereign was fully bonded. And obviously, that's not the case with the idle wells, but they were bonded through, specific to those wells by Jones, through September 16th. And so I want to go through this detailed plan because, again, what Sovereign has done and its ownership in these wells, along with the special purpose entity that owns these, has to come out and work on all of these wells. Again, we've worked on 19, we've MIT'd 17, we plugged and abandoned 6. This plan before you on the spreadsheet is broken into 3 different sections, broken into 11 wells to be worked on. Yeah.
You do have in front of you what is referred to as Schedule 2 at this time. We had filed Schedule 1 on Friday. I want to make sure you're looking at the most current plan, which is Schedule 2 shown as this. Thank you.
This is an update of what?
Yes.
It's a schedule that on the top has 1, 2, 3, 4, 5 wells that are in red. The rest are all in black. These are the wells that we've worked on at this point. So this plan looks at 34 wells in total. We've already plugged and abandoned 1 well. We plugged that back in January. Then the plan is broken into three different time slices of 4 months each for a total of 12 months. First slice is 11 wells in green to be concluded by August of this year. Second, in yellow, another 11 wells to be concluded by December 1st of 2015, and the balance of them in orange to be concluded April 1. We have a rig in the field. We've already brought 3 wells back on production, 2 last week. We have a rig standing on the Traherne A number 1, which is the last well on your list, or the 4th well in red on there. We will keep the rig in the field and continue to work on these wells. And so the plan effectively looks at these in 3 different categories: to either put them back on production, to plug and abandon them, or to post the idle well bond. Sovereign, with its cash flow, really, it's much more important for us to put this money in the ground than to post the bonding. We're capable of posting the bonding, but it's really more, we have to post a cash bond, so $620,000 is a hardship. But we really want to put the money in the ground, put these wells back on. Baca County is, as you know, in the southeast part of the state, not a lot of services down there. We have 4 pumpers that work for us, and we'd really like to keep this field, enhance it, keep it running, keep those people employed. So back to this, the operational plan is under 3 different categories that we would conclude within each of those 4 months. We would give a report during that period of time to staff to show the progress. The other thing that's listed on this operational plan is that we have received some field inspection notices on 20 wells. They're noted in X about midway through the spreadsheet. About 20 wells have received field inspection notices. We have a roustabout crew in the field right now. They've been out there for about 3 weeks. Most of these items on the field inspection notice are repairing tank berms, putting labels on tanks, signage at the road, weeds, could be tumbleweeds in the tank battery that need to be taken out, could be spraying weeds. They're all being sprayed now. So we have an existing roustabout crew that's working on all of these. And of the 20 field notices, we've completed 10 of them. I believe we filed our Form 42s last week. I think we filed 8 or 9 of them. There are 10 nearly complete. Those are a combination. There were, the staff's note said there were 9 wells that had some excess, basically salt water, production water. It's actually 8 wells. 7 of those wells preceded our operation, that our operation took over in 2011. 7 of those wells haven't produced since prior to our operating. Some of those wells never produced. So recognize that excess salt water is a bad thing. We've applied a gypsum to all of those, and we're doing our remediation plan. That's the 10 that are nearly completed, and those will be filed likely this week. So of the field notices, inspection notices, we're ongoing operations there. In dealing with that. Just go ahead.
Just to clarify a few things, looking at Schedule 2, the idea here is that you will specifically complete 11 of these wells within the first 4 months, another 11 within the second 4 months, and then another the final 11 within the final 4 months, and the entire project will be completed within 1 year.
That's correct.
But this is more of a planning document for you in the sense that it's entirely possible that the 11 you choose to do first could be from different thirds of this plan.
Yeah, we need some optionality so that we can move the rig to the wells that are allow us to stay on that schedule.
And would you explain who Colton LLC is?
Colton LLC is an operator that's been in Colorado for quite some time. Sovereign Energy, acquired Colton LLC in 2006, drilled a lot of wells around Greeley. Colton has full bonding, cash and a surety bond in place. It operates about 8 wells. What we'd like to do is we'd like to move the Colton $60,000 of bonding to Sovereign, have Sovereign operate all those wells so that we can have some additional bonding in that mechanism.
So that would be a matter of simply changing the operator of those wells from Colton to Sovereign? Is that what you can do?
Yes, they're all producing wells. I did speak with Martha Ramos about this subsequent to our December 5th meeting, and she came back and gave me some input on that there were 20-some wells that we had filed permits on. They were all abandoned locations, and those needed to get passed via an inspection by the Oil and Gas Commission before we could move that to Sovereign. We have not followed up with that discussion with Martha because we've been working on this plan, but our desire would be, since those have all passed, to move those, it's now 7 wells with Colton, into Sovereign's basket and use the bonding appropriately.
Just to provide a basis for getting exhibits into evidence, I'll ask you about certain documents that were attached to our pleading on Friday. Exhibit A is the plan you submitted to the staff on December 5th. Is that correct?
That's correct.
And that was prepared by Sovereign and by you?
Yes.
Tom, I think we could dispense with the formalities. I don't have any objection to those exhibits.
The admission of all exhibits in?
Yeah, that's fine.
Okay, thank you. I do want to have you talk a little bit about Exhibit C, which is the final proposal you made to the staff as it relates to the work to be performed on these wells. Is that other than the one that's embodied in our Friday pleading?
What's your question?
This is the last proposal we made to the staff.
Yes.
Prior to our Friday filing.
That's correct.
Okay. Did we ever get a response from the staff on that proposal?
We did not.
Until we received their objection.
That's right.
Okay, now, how are we proposing to, so you filed on Friday a plan that involves these 33 wells. Breaks it into 3 different groups, but now you're amending that plan further by proposing the addition of another $60,000 of security through Colton. Is that correct?
That's correct.
Okay. So that's a further amendment to the plan that you've already seen, and we would ask the commission consider that in addition to what it's already filed in front of us, that additional security. You've seen Exhibit D. That is a notice that was received by my office and forwarded on to you related to the fact that the number of shut-in wells is considered now to be something far greater than 21 or 22 initially.
That's right.
And you do not disagree that these are shut-in wells.
They are shut-in wells.
And we intend to address these wells at this time.
We're already working on one of them, brought one of them on back in production.
And they're part of our list of 33 that's in front of the commission. All right. So, with respect to all 33 wells, one of three things will occur. What are those three things?
We will put them back on production, which our efforts are ongoing in the field now. We will either plug and abandon those that are unable to establish production, or we will post the bond.
Would be your preference to invest available capital into restoring production of these wells over providing security for their plugging and abandonment?
Not only our preference, but that's been our plan from the get-go to do that.
Does staff or the commission have any questions of Mr. Metzger?
Questions?
Just a couple. Can you go into some more detail on the Colton bonding? Because my understanding was that was not money that could be transferred over immediately. So what's the contingency that would allow that money to?
And I don't know the date of Martha's letter to me, but the reason I believe the reason it couldn't be transferred over immediately was that there were the 21 wells with which we had permitted locations, which we never pursued. Colton subsequently sold that property to Noble in 2011, and really those appear to be Noble's issues, but because they're still on, apparently they're still on Colton's bond, which is an active bond. The commission needed to go out and look at all of those sites to verify that those passed. Those have all been done. I've received all of those field inspections, and so I don't know that there's an impediment to moving the 8 Colton wells under sovereign operating bond and moving the 60,000 over with it.
But it's not cash. It's a bond in somebody else's name with some contingency on it. So it would need to be, something would need to be fixed or clarified before.
It's half
it could
cash,
be,
half surety bond.
Yeah. But what I'm saying is there's a contingency for that money to slide over into an inactive well bond.
Jeremy, I guess I don't understand what you're saying.
Should something have been revealed in the inspections that occurred recently, that money will not make its way over, correct?
Well, our proposal is to immediately cause that capital and that surety bond and that cash to provide support for the obligations of sovereign with respect to these 33 wells. And we'll do whatever is necessary to cause that to occur.
I understand, but Martha Ramos has to approve that before it can actually happen.
I'm sure it's true.
The other question I have is with respect to this plan, this schedule, you lay out 3 groups of wells. 11 wells will happen in the first 4 months and so on, but there's no specificity as to precisely which well. It's sort of up to your judgment as to which of these many wells will be handled first and which will be handled last, correct?
Well, that's correct, but that's specifically set up so that we have the optionality. We're agreeing to do 11 wells every 4 months. For a total of now, I think actually the 34 wells is now 31 wells that need to be addressed because we've already dealt with 5 of them. But we need the optionality due to crews in the field, amassing services at a certain time, roads in the spring can get muddy, personnel, farmers with crops, farmers requiring us to, there may be working on their road. We just need some optionality so that we can address the 11 wells, but we need to be able to ship those around.
So with that optionality, could you delay the most troublesome, the most expensive well until the end of this plan?
Could we?
Yes.
I mean, we have the option to do any of that. We're trying to work on the wells that are quickest to put back on production. The other thing is the last wells in the setting. Jones, when they bought Crusader, came out and drilled a bunch of brand new wells in 2008. They all have new surface equipment, new casing, and literally they got no production out of those wells. The wells have really had no production history. Those wells were perforated in a variety of different zones. We need to go in and isolate those. They're going to take a little more work to do that, but the wells are in very good condition. And so those are kind of lumped toward the end because, frankly, I think those need a little more effort.
And just to clarify, they were spud in 2008 and have not produced since. Is that correct?
They drilled 8 or 10 wells in 2008, were unable to establish production. We've paid shut-in royalties to keep those leases in place because of our deeper objective. Most of those wells did not have any sustained production at all.
That's all the questions I have. That's all.
Okay. Anything else, Tom?
I have a couple more questions, please.
Yeah.
Describe the nature of the production in this area. The commission may not be familiar with the nature of the production in this area.
Yeah, these are low BTU gas wells out of the Topeka, about 3,200 feet deep. They don't have oil production. There are no oil tanks on site. It's the separator separates water, which is hauled to a commercial disposal. The gas goes downstream. Very, very little liquids and very little opportunity for environmental impacts because of that.
And what has been your experience with respect to plugging costs? What do you expect them to be in this area?
Our experience is about $18,000 on average to plug wells.
And you expect to plug wells only when you can have reestablish production from those wells?
Our desire is to use our funds to put as many wells as we can back on. There will be wells in this group that won't make that grade, and we'll need to plug them. But our desire is to enhance as many wells as we can. I have a couple last thing to say. Sovereign Operating Company and its Sovereign Energy, Colton LLC, in business since 1993. I know the staff has concerns about an operator leaving the state with a plugging liability. I completely respect that. Sovereign Operating Company, we operate in 3 different areas. We spent a year and a half with the city and county of Broomfield. We filed 31 wells in the city and county of Broomfield. We spent a year and a half working on a best management practices MOU. Maybe some of you have heard about this. We voluntarily did that. It is the strictest MOU in the state and far beyond the state's boundaries. We have a lot of requirements associated with that. We intend to be an operator in the state of Colorado for a long time. Our reputation is very important to us. We want to put our cash to work in the oil and gas fields. And we wouldn't have signed that MOU if we were a derelict operator and didn't want to live up to our responsibilities. We care about our reputation, and we respectfully request that you give this real consideration, that we be able to work on these wells in a timely fashion, as opposed to putting this money idly to bond these wells. Thank you.
By MOU, you mean Memorandum of Understanding?
Yes.
An agreement with the city.
With the city and county of Broomfield, right.
May I jump in briefly? First, I wanted to note that Commissioner Spielman joined us at about 1:29 p.m., so he's heard the majority of the testimony. I also needed to clarify this is not an enforcement hearing. This is a general hearing matter. And Sovereign, you have about 18 minutes left. Staff, you have about 16.
We do, or?
We have 18 minutes. We'll reserve that for the closing. Thank you.
Staff
presentation.
Any commissioner questions, or take that as a no?
I hear or see none.
Thank you, commissioners. Jeremy Farron, enforcement officer here at the commission, and I'm serving as staff advocate again to summarize staff's objections to this plan. There are numerous members of staff present to address your questions if you have any, but I do need to jump into a couple points of clarification. There's various well numbers in the documents, and I apologize for that confusion. We started with we have 33 inactive wells pursuant to the commission records. So they have apparently returned some wells to production. Commission records don't bear that out. Initially, we thought there were 21. That was based on some bad information from the database. We've since revised that number up to 34, and they have apparently plugged 1 well. So what we're talking about here is 33 inactive wells. That explains the late filing too. I asked the applicant to sort of supplement to address the wells that we thought were at issue. We're also preparing to begin an enforcement action on this matter, assuming you deny the application. But just so you know, because of that, we're not going to get into the number of wells, the amount of money due, what's due and owing. This is just an opportunity for you to hear the application and then to just decide, hopefully, to deny it. Commissioners, Rule 707 lays out a very specific variance process, and it's one of the few rules that does. So if the right operator can come forward and thread that needle, then a variance should be granted. And I respectfully submit that Sovereign has failed to meet that burden and is not entitled to a variance. Therefore, staff asks that you simply deny the application. As I said, staff's concerns with the plan and with the application were submitted in an objection to you folks, but I will quickly highlight some of that here in this PowerPoint. So that's the rule. It's not the most easiest rule to understand, but it essentially boils down to a math formula, which I'll get to in a second. There's a good chunk of it that just talks about the variance procedure as well. Three important definitions: the definition of an inactive well, a shut-in well, and a temporary abandoned well. I won't dwell on that because I don't think they're contesting that these are inactive wells, so I'll just skip to the next one. There's the math formula, and here it is applied to the 33 wells. So you just take the number of inactive wells that are shallower than 3,000 feet, take the number of inactive wells deeper than 3,000 feet, do the math, subtract the existing financial assurance, and come up with a number. Here are the well names. It's not particularly helpful. Here is a map showing the well location. So this is the southeast corner of the state. That's the Kansas border right there. Not every red dot is a sovereign well, but this is just the general location of where these wells are located. So some of these wells, and we just talked about this on Cross, some of them have not produced for 10 years, 9 years, 8 years. Some have never produced. They were spud in 2008. A whole slew were shut in 2009, I assume in response to a drop in commodity prices back then. So there's just a number of wells that have been sitting there idle for some time, and that's disconcerting to staff. So like I said, there is a variance procedure in the rule itself. Here are the various factors, but the two most important factors, at least in my estimation, is the cost of plug and abandoned wells and any sort of environmental issues associated with the property. So I'll jump into those two here. So Sovereign has just testified that they believe it will cost about $18,000 to plug and abandon these wells. I walked into Denise Arthur's office, who is the reclamation supervisor, and asked her to just give me a back of the envelope estimate of what it would cost to reclaim the surface. And she said, any well in Colorado probably starts at about $15,000. So the idea of having this variable in the rule is if you could come forward with definitive proof that your wells would cost something less than $20,000, then you would be entitled to a variance. It just makes sense.
I would object. This is all hearsay as it relates to the cost of reclamation.
I don't think we'll grant your objection because it's hearsay, but it's coming from staff. He's an advocate for staff. I think we can accept their estimates, back of the envelope estimates.
A rough estimate for sure. So like I said, if you could come to the commission and say, look, it's going to only cost $10,000 to not only plug but reclaim this well, you shouldn't demand $20,000. That's not fair. So what I'm telling you is it's probably going to cost roughly 33 grand, which is greater than the 20 grand we're even asking. So I just wanted to point that out. By their own estimation, they're really not arguing for a decrease in the bonding amount, but by their own estimation, it's going to cost more than even the 20,000 we're asking for. Like I said, environmental condition of the wells, that's very important. Because of the early confusion, we scrambled inspectors and they only went to 21 of these locations, but of all 21, they found deficient they found deficiencies. So each inspection is a corrective action required inspection. So there was something there that was amiss. And it could have been something simple like a sign or a berm, but of 9 of 21, 42%, the EPS in the area was Dr. Gintanis, who you just heard from, I think last hearing. He found apparent produced water impacts at 42% of the 21% that we identified. Again, I point to this factor as, you know, if you're going to come to the commission and request a plan, if you're going to request a variance from 707, you need to come forward with, I hate to say it, but pristine locations. They have to be, you have to be able to eat off of them. And unfortunately, we found problems at 42% of the few we visited. So I don't think a variance is appropriate where we found that. If it was maybe 1, we could talk, but it's 42%. And as Dr. Allward knows, produced water spills are pretty hard to remedy easily. It takes time. So I'll give you some visuals. This is the Thompson Jeffries. You can see a sample location there next to, I think that's a tank. And we found electrical conductivity, which is EC, at 14 times permissible levels. We found sodium absorption rate, SAR, at 3 times permissible levels. That's compared to our Table 910 standards. Laughlin Federal, we've got EC of 7 times and SAR of 3 times. You can see his sample location there, the various little dig holes. Gibson, it's not as bad, but it looks like it's got a larger aerial extent. It looks like a larger portion there. It's where the text is down on the bottom. It looks like we've got EC at 3 times permissible levels. St. John 136, this is the worst of the bunch, 25 times permissible levels of EC and 6 times of SAR. And you can tell that it's impacting this farmer's irrigated field here because nothing will grow down gradient of this location given the EC and SAR. So to put all the factors together, we've got 33 inactive wells. That number might vary based on what they've returned to production, but essentially 44% of this field, and I ran the numbers field specific because of the way Sovereign operates. They are field specific. So they want you to include wells up in Broomfield, and I don't think that's an appropriate analysis. Again, the cost to plug and abandon these wells, it's greater than $20,000. I think if it was $20,001, you're not entitled to a variance. Business reasons, recent prices, that may or may not be the case. I think even when prices were higher historically, these wells were not returned to production or plugged and abandoned. Environmental condition, we just talked about that. Produced water spills at 42% of their locations. Financial condition of the operator, I like to hear testimonies that they're upstanding, that they will not abandon these wells, but unfortunately, I can't just take them at their word. And then ability to manage this plan. They submitted a plan early. It had some dates in it, some timelines that have actually passed, and some of those dates, they've even failed to comply with their proposed plan. So I find that troubling as well. Availability of plugging and abandoning services. I don't know. They mentioned that quickly, but I don't think that's a real big issue here. So Sovereign's burden is to either come forward with, I think it's evidence to prove that plugging these wells will cost less than $20,000. I think they've failed to do that. And then to come forward with a plan for either plugging wells or returning them to production, an acceptable plan. I think that means acceptable to staff and the commission, obviously, and then a timely plan. And on the face of it, while this plan has drastically improved, and it's now down to 12 months as opposed to 14 or 16, whatever the prior plan was, it still lacks the detail that I think it would need before staff could recommend it. So I feel like Sovereign has not met their burden here. So in conclusion, I don't believe they've satisfied their burden. Compliance at these wells is long past due. We've got higher plugging and reclamation costs. We've got environmental issues, and they've proposed a plan that we feel is unacceptable. So we would ask that you deny the application And I need to respond to a couple things that appeared in the amended application that was filed on Friday. The first is the idea that the prior operator's bond has any bearing on this matter. It simply doesn't. That's an insurance bond that was in the name of Jones. That was for the benefit of Jones. That has no impact on Sovereign. We couldn't have claimed that bond because we would be going after the wrong operator. So Rule 707 is specific to the operator's inactive well count. And so when Jones sold those wells, their count went down, they were over bonded, and we needed to refund that. It actually wasn't cash, but we needed to release that bond. And so when Sovereign bought those wells, their inactive well went up and they were under bonded. There is a stray statement in the letter releasing that bond that talks about Sovereign being fully bonded. And that is actually a reference to 706, which is the $60,000 statewide bond. It's not a reference to 707, which is the matter in front of you guys. There was some quick discussion of Sovereign's capital structure and the fact that they're a contract operator. And to be honest, that's disconcerting because they apparently lack collateral in these wells. There seems to be no internal incentive to maximize production, to return these wells to production, because Mr. Metzer mentioned he had a personal interest, but the company Sovereign doesn't have an interest in these wells, a revenue interest, in order to sort of foster, in order to encourage them to return these wells to production. So that's a little disconcerting. The environmental issues, there's just a stray reference that they're on top of this. They're going to go out there and fix these produced water spills. And part of that plan is to put some gypsum out there and to submit a plan to us. But that's just the beginning. We want to see a plan. It needs to be approved. It may or may not include the application of gypsum, but it's certainly going to require time and money and manpower, and I've been told water. So that's how you remedy produced water spills. It's a lot more intensive than a roustabout crew and a bag of gypsum. I'm sure, as Dr. Allward could attest. So with all that being said, staff's position is that you should deny this application.
Any comments, questions? Director, did you look in your eyes?
Before I say anything, is the record closed, or is there a response from Sovereign?
We'd like to respond, and we'd like to reserve some portion of that for after the deliberative process as well, because we want to hear how this goes and then maybe make further comment. I
need to get some advice and counsel on whether or not you have an opportunity to respond after the deliberative process. I don't think that would be available.
In that case, we'd like to respond now then.
Okay, just one, give me 30 seconds.
Oh, sure.
Before the response, the commissioners have any questions for staff or Sovereign?
One question for staff. I think you mentioned in your summary, you said that Sovereign does not have any interest in the well specifically, so they wouldn't be necessarily encouraged to return them to production. Is that what I heard you saying? But yet I think they testified that they're an operating company where they derive their income from operating active wells. So wouldn't they be encouraged to return a wells production so they can get some income from charging an operating fee to operate the wells?
Again, without knowing all the details of their agreement among the parties, I think the typical understanding is that you're a working interest owner, and so you're encouraged to return wells to production as a working interest owner in order to maximize your own return. So again, I don't know the details of their capital structure.
In a lot of cases with small volume wells, if you have an operating company, they derive a fair amount of income from managing the wells and operating them for the other working interest owners, because that's how they make their living, is managing those wells effectively. So there might be some incentive there. That would be my only comment. Even though they don't have an interest, they may be incented to keep those wells or get them back on production.
Any other questions for any of these folks? Okay, Counselor.
All right, thank you very much. First of all, I'd point out that there's, this is commission policy that's been established that I'm not familiar with. There's, looking at Rule 707A, there's no reason that the environmental condition of the property must be pristine as suggested by Mr. Farron. Quite frankly, the environmental condition of the property is very good, and I believe they can certainly cite shortcomings in the field, and they have, and we've addressed most all of them. Secondly, you remember Mr. Metzger's testimony about the 9 wells that do have some evidence, perhaps there's only 8 or 9 wells that have some evidence of water contamination on the surface, that those contaminations occurred prior to this operator being in possession of the properties. And they're doing what they can, at least preliminarily. Thirdly, with respect to the idea there's no incentive on the behalf of this operator to address these wells because there's no economic interest, there's 2 things about that that are obviously flawed. The first is that we are addressing them. We are underway in this remediation action at this time. We have a rig out there working right now. Only this operator, Sovereign Operating, does not own an interest in these wells. That's true. However, Mr. Metzger does through these single purpose entities, and so he's a cost-paying party as well. Finally, I could be corrected on this one, but he has made, Mr. Farron has made much of the fact that the reclamation costs need to be considered, and that may be well true, but the provisions of 707A refers to costs of abandonment, plugging and abandonment. It doesn't refer to reclamation. That's to be considered by the commission. I wouldn't necessarily blame the commission if it wanted to consider reclamation as part of that, but technically the words of the regulation refer to plugging and abandonment. I think it's important that you look at Schedule 2, which shows the plan and shows what has been done and what we intend to do. You know, you have a chance now to consider the plan itself, and it's been pointed out by Mr. Farron that failure to approve our plan will result in immediate enforcement action brought by the COGCC. They're ready to serve us now at the end of this meeting. I think this is an operator that should be given some latitude and should not be subjected to that process. I think it would be appropriate here that if you're not able to approve the plan today, we think you should, that you at least continue the matter until perhaps further conversations can be had with the staff to see what shortcomings they have with the plan. They have told us lately, when we proposed this plan, it was suggested to us by the staff that this is a step in the right direction, but there are more details need to be worked out. We would like the opportunity to work out those details. We very much want to avoid the NOAV scenario where we start that legal process. And so if you would instruct your staff to not do that, that'd be great, because that would incentivize us to continue our discussions with the staff, which we'd probably do anyway. But it changes the legal environment for us, puts us under pressure that's probably inappropriate in this matter. Given the character and the nature of these operations, we would urge you to consider approval of the plan first. Secondly, if not approving the plan, perhaps continuing this for a period of time so that we can have further discussions with the staff, iron out whatever details or difficulties they might have with our plan. They are generally disposed to it, as far as I understand, but they would like more time to work with it. In that meanwhile, if that time is given, further progress can be made on these 33 wells, which we intend to do. So this is hardly an operator that can, it's been suggested that we need to take immediate action because bankruptcy could occur. Well, that's not in the cards for this operator. I know Mr. Farron can't rely on those assurances, but I think the character of the people involved here would make you believe that, and would ask that the need to move this into an enforcement action immediately is pretty unclear to me. Thank you.
Okay, we have.
One other item.
Should we close? You want to ask a question?
One more item. I mean, again, this is for staff. I'm sorry, this is going to be asking you to speculate. Presumably, if they're on a path to do some work, and it looks like they've been sort of diligently at this for a bit here and have started to work down through the list, do you think that there would be a material change in the level of contamination that you've already measured between now and, say, the end of August to any of these locations, or a material change in the financial condition of the operating company between now and then?
So
is that what's potentially driving this? Is there's a concern that they may escape to, Lower Slobovia or someplace like that, and nothing happens on these wells, or that there's ongoing issues that are going to change with respect to the wells conditions that are material in nature?
So I can't address the financial condition of the operator, but I can say that we did not inspect all of these locations, so we don't know if the environmental condition could get worse, or if it is already bad and stays bad. So that is the concern.
Any other questions? Okay, no other questions, and we'll close this portion of the hearing. And close first, then you.
Yeah, quite candidly, Mr. Chairman, I'm a little uncertain as to where I should weigh in, but I do have some thoughts and comments about the matter, why we have taken the position we have taken at this particular juncture. So, again, I'm not sure where that best fits in.
Well, I have no idea, but I think
If I say it now, then perhaps both staff and Sovereign would have an opportunity to respond to my comments, and that
would
might
be my
seem fair.
understanding. Yes.
Okay.
That would be appropriate. You'd allow them to have. It would be good for them to comment on what you comment on. Yes.
Sure,
okay.
I think so.
Let's go that way.
First, understand that staff has been working on this for quite a while, and that I've only been focused on it fairly recently. Second, it's been moving quickly in the short time I've been focused on it. You heard that the most recent plan was submitted Friday, and there was, lots of conversation about that. I am not fundamentally opposed to Sovereign's proposed approach of a phased, staged response where a certain number of wells are getting taken care of, either, and what they propose to do is exactly what 707 requires, either return the wells to production, shut them in, or P&A them, okay? I am being very risk averse here. 33 wells currently shut in. If Sovereign did declare bankruptcy, did walk away, that's $1 million+ liability for the commission. While this was pending, we had the Red Mesa matter. Understand different operators, understand many different facts. I also understand that Red Mesa took the opportunity of a continuance from one hearing to the next to declare bankruptcy. So I'm being risk adverse. Were we to issue an NOAV, we would, if Sovereign would join us, negotiate a resolution to that NOAV that essentially incorporated their plan that they've put in front of you in a variance. We do think there are some hard details missing from the plan, but our starting point would be, if you carry out your plan timely, meet deadlines, etc., the NOAV is resolved through that avenue. Now, one thing that is missing from their plan is any immediate increase in bond, right? Understand, and Mr. Metzger put it well, this is an idle well bond. They have a lot of idle wells. There's a reason we have that added bonding requirement. So maybe one thing we would like, these are the details to be ironed out. If there was a little good faith money right now today, then this plan ensues. Then there are provisions that if they fail to meet the plan, just like any other mortgage lending accelerated payment requirement, right? So if after the first quarter, you have not met that 11 wells requirement, we reset. And maybe we reset by saying that was your last chance. Now you owe us whatever you owe us. So that's what's in my mind. We want to give you time to reasonably work it out. Putting wells into production is better than us sitting on a whole lot of money that you could use appropriately to remedy environmental impacts, bring wells onto production. We're uncomfortable, though, that if all you leave here, if you approve the variance, there is no order hanging over their heads that gives us some leverage should the worst outcome come to pass. That was where my thinking was.
Yeah, Sovereign have a response? They care to offer?
Thank you for the comments, Mr. Lepore. We're pleased that the basic outline is not totally objectionable to the director. We did offer some additional security in the form of Colton, the additional $60,000, which would be added to our bond basis, our security basis, in effect covering 6 wells. In addition, 4 wells are already off the list. So we've already pretty much met the first 4-month obligation to do work on 11 wells or bond them, I think. Yeah. So we're moving in the right direction that way. If it helps, there's a desire to put us under the acts of enforcement. I respect that. We respect that. They want to serve us immediately to put us under a gun for a May hearing. We're hopeful that conversations with the staff will work that out and resolve all the details that you referred to. But if it assists in any regard, we'll agree to stipulate to a reduction in the time frame to give us notice on the NOAVs if you get to that point. You don't need to give us 35 days notice. You can give us 2 weeks or something like that. So we're not we're not bargaining for an opportunity to declare bankruptcy here. We are just simply trying to avoid the process of being under an NOAV with a very good operator here with a plan that it's performing on already. We'd ask for a chance to complete that plan. We are willing to work with the staff to further refine it. We just don't want to be under the hatchet of an NOAV. And thank you very much.
You made progress from an axe to a hatchet.
Thank you.
There's a lady I was hoping to hear from.
Yes. So Martha Ramos, Financial Assurance Supervisor, she can address the Colton issue. So.
In order for the bond to be...
Excuse me, just go ahead and introduce yourself so the folks out in the
I'm
in
Martha
the cloud,
Ramos, Financial Assurance Supervisor. Colton does have a $60,000 bond, plug-in bond. They, the last record I seen, they had like 7 active wells and about 24 abandoned locations. I did request inspections to be conducted on those abandoned locations. I don't know what the end results were, whether they passed or not. But all obligations for Colton must be met, which means, all wells must pass, all pits must be closed. Any complaints, any remediation projects need to be resolved. We look at all obligations before we can transfer that cash bond over to Sovereign. And we would have to transfer the active wells if we want to totally transfer the full amount to Sovereign. The other thing that we can do is also they can add Sovereign as a rider to that $60,000. And so both companies would still exist, but that $60,000 would cover liability under Colton and Sovereign. So The other option that we also have is a payment plan for Sovereign if they would like to bond up on a monthly basis for whatever, if a variance is granted for the dollar amount. And that is totally negotiable. And that we would like it resolved like within 12 months, whatever the excess inactive bonding requirement is.
Thank you. Question?
Let me tell you what's going through my mind right now, because I understand from a cash management perspective, coming up with an additional $600,000 ASAPs. You know, that's going to be really tough to go ahead and do. But at the same time, I keep thinking about the possibility, and this, you know, this may not apply to you, but we have some operators in this state that, I'm sorry, I don't want to cut them any slack, because I just don't fully expect them to P&A the well or to return it to production on a reasonable, you know, period of time. Looking just at the numbers, what we're talking about here is the time value of money of $600,000 versus the amount that it's returned to you either because the well is properly P&A'd and reclaimed or the well's put back on production. Now, $600,000 is an awful lot of money. Maybe that's, you know, too much. $60,000, that's just not enough of an incentive just to spur everybody, you know, to spur you all on to make haste and get these wells either P&A'd or to go ahead and get them on production. I'm happy to hear that Director Lepore thinks there's something in the middle that maybe we can go ahead and negotiate so that, you know, it keeps you moving forward. There's some, you know, penalty out there that's possible, but that the right thing gets done in a timely fashion. I quite frankly don't know what it is. I know that I don't like the 600,000's got me concerned because that's a lot of money, and you're right, that could be used to actually go towards, you know, getting these wells handled. 60 doesn't hurt enough. So I need help. I don't know where it is in there, but I know I don't like, it's somewhere there, but it's not. I don't like either one of those. It's just too much.
There was sort. Commissioner Allward, did you have comments?
No, I should not close note myself.
No. Personal note. Councilor.
Commissioner Craig, if I can get back to what you just said, I think your decision point today is, do you grant the requested variance and adopt the plan or not? It's not, do you immediately instruct Sovereign to
Post the bonds?
Post a bond of $600,000. And I think that's what Jeremy is discussing about whether to issue an NOAV, serve Sovereign now, and have a hearing in May, really to consolidate the two issues. It would be sort of a Sovereign at that hearing would certainly say, look, we want this variance, and this is what the current variance looks like that we're requesting. And on the other side of the fence is Mr. Farron saying, we think this is inadequate, or we think it makes sense, or we support what Sovereign is doing. So I think what Mr. Farron is asking for is just sort it out at the May hearing when he has the equivalent of what's the counterclaim against Sovereign for the full bonding amount. And Director Lepore is saying, we don't disagree with what Sovereign's trying to do. We just don't like it in the context that we've been given at this point. So one thing you could consider would be to effectively consolidate all of these arguments and take it up again in May, where staff would have the opportunity to present the OFE and the NOAV, and the dialogue could continue between staff and Sovereign to perhaps flesh out the remaining details.
Thank you for explaining.
Is there a regulation, policy, legal reason why it would have to take place in May? Could it take place in July, whatever the next one is?
No, I don't, there's no immediate need. We have talked about bankruptcy, and I'm not casting aspersions on Sovereign. In terms of a potential bankruptcy filing, I don't see any emergency need, and I know that Sovereign is not on the verge of bankruptcy, and we all take your word for that, but it's something we have discussed recently in the context of another operator. So I don't see an exigency today for you to enter an order and take action either way.
So may I ask a question then now that, just for clarification, what I thought I heard you say is potentially we could say, we deny the application, in which case you go to the NOAV and they show up in May or July or whenever with a hearing, and the outcome is that essentially to avoid any material fines, they comply with this schedule that they've already set forth. And there may be some bit of extra incentive in there to perhaps say, okay, well, you need to increase your, work on a schedule to increase your idle well bond. And as you're paring down your idle wells, you're also working on a schedule to ratchet the bond up. Is that what you said?
I think it's part of it. If you were to grant the variance today, and Sovereign would default under its proposed plan 3 months from now, 4 months from now, the result is a further hearing. And I think one of staff's concerns is, and I know Director Laporte's concerns is that if you hold an NOAV hearing and issue an order finding violation with a deferred penalty amount, which is frequent in our orders, it provides real incentive for Sovereign to comply with the plan.
Okay. Thank you.
Okay, we're going to close testimony.
Mr. Chairman?
Yes, sir.
There was some more testimony given by the staff here. I would like to consult my client for just a minute before we close our case. Thank you. Thank you. We're finished. Thank you. We have concluded. Thank you.
Okay, then we're going to close testimony, if that's okay, Ms. Murphy, and we will deliberate. We have before us the question of whether or not to approve this request for a variance.
Mr. Chairman.
Mr. Spielman.
I'm prepared to offer a motion if the chair would entertain it.
Sounds entertaining to me.
Well, we'll see about that. I would move for denial of the requested variance.
Motion?
Second.
And a second. Discussion.
I'll start it. So, but certainly can't offer a lot of, I think there's more insightful people on this commission than me with respect to this, but it seems like there should be some way that we can get someplace that we can encourage Sovereign to continue down that path and also satisfy the concerns of the staff about sort of incentive to be compliant. Because you look at what they've done so far, they've worked on 5 wells, and of those 5, 3 of those have been returned to production. So I'm reluctant to impose a significant financial burden on the operator when they could be taking that money and using it to turn the wells back on, work the wells over, turn them on, and clean up the damage. So if there's somehow that we can work that within the next step, it would
be pretty useful.
I'm in the same boat that they've demonstrated some progress. They've demonstrated, I think, a willingness to try to solve this. But I very much appreciate staff's work at calling this to their attention. That this does need some mitigation, some work done. And I appreciate that. Director Laporte kind of won me over with the concept of if we deny the request in whatever time frame, an issue or notice of alleged violation, and we're going to have a period of time where you can work out what the parameters are, what the target dates are, what needs to be done, the financial aspect of bonding and so on. And I think we would be in a place where we'll continue to get this good work accomplished and get more of those wells back in production, which I think is good for pretty much everybody. And then wells that aren't capable, we're going to get made. My judgment at this point would be that's the best direction to go.
Mr. Chairman, if I may, I don't disagree. I think that's a question for another day. I think the question before us today is, have they met their burden to warrant the requested variance? And I think that question only, the answer is no today. Thank you.
Thank you for clearing away the chat. Any other comments or suggestions, or Director Allward is contemplating?
And so I don't want to add to the chaff, because Commissioner Steelman very clearly brought us back to what the question is. But I was pleased with Director Laporte's clarification of how things could work to the benefit of all. And I've agreed pretty much with everybody so far, but I do want, this bonding for idle wells is important, because without it, we're imposing risks onto the state, onto the people of Colorado. And that's not a business model I really think we should support. But sometimes we're really up between the proverbial rock and a hard place. And so I'll probably reluctantly go along with the motion in front of us.
Just to add to that, I heard what you said. I was reminding myself to look real quickly on the staff report at the plugging and reclaiming abandoned wells section, and we're working there. There's a big bunch out there to continue to work on. We don't need to add too much to that if we keep running. Okay, the question has been called. Those in favor of the motion, which is to deny the variance request, indicate by saying aye.
Aye.
Opposed, same sign. I'm sorry that, no, I'm not sorry. It has been denied.
Understood.
But I think we're going to make some progress on this.
I would have asked if the commission considered guiding the staff in this regard to not initiate the NOAV for a period of time.
Well, I'm not sure. Well, I better get some advice. Director, do you want?
What I would like is a 5-minute break between this and the next matter. And then I would like Mr. Matter to meet me and Mr. Niebrugge and his client outside.
Oh, no.
Two of them don't want to come back.
Okay, if that's okay with you folks, we'll do that.
All right.
So we will take a 10-minute break because I know how you guys work.
requirement to put up additional assurances, there's no ability for the bankruptcy estate to pay it. That would be my first point. In terms of a plan, I think that the Chapter 7 trustees' goals and the commission goals are aligned. And by that I mean, I think that our objective here is to find a purchaser for these assets and a purchaser that would be a moneyed buyer that would have the ability to assume the obligations of operating the wells and dealing with the maintenance and other regulatory obligations. So in that regard, I believe that, again, our goals are aligned. I think if there is a requirement to put up this additional financial assurance, even if it's just a placeholder. I'm sorry. I'm sorry. Apologize. I had the YouTube thing going here, so I'm hearing myself delayed. All right. I think that if there were an obligation to put up this additional bonding requirement, even if knowing that the estate couldn't pay, I think just having the overhang of that could potentially chill our ability to attract purchasers to these assets. And I don't think that's in either of our best interests. Those are my two chief points. The third point I would make is that it appears from the application that, at least with certain of the wells, there seems to be, at least there was a belief that there was an agreement that perhaps 4 of the wells should not be part of the request for additional bonding requirement. And that's really set forth at the top of page 2 of the application. Those are the only points I have, and I'm happy to answer any questions that the commission may have. I note that there have been inspections that have been done. I know that there are some issues that raise immediate concerns. I note that there's a representative of the Chapter 7 trustee that has flown out to Colorado. My understanding is that he is there today and is meeting with one of the inspectors from the commission. And we're going to try and work with the commission to address whatever immediate concerns that we can to the best of our ability. And in that regard, we have had several conversations with Mr. Farron. I spoke with Mr. Holden on Friday and Ms. Beckstead. So we are aware of them. We share those concerns, and we're working with the commission to address them, again, as best as we can within our means.
And are there any commissioner questions of Mr. Karakoff?
Commissioner questions? There are none.
Well, then I will quickly proceed with staff's remarks. Jeremy Farron, Enforcement Officer, once again, serving as staff advocate. Again, I'm going to summarize staff's objection to this application. Commissioners, we just heard the sovereign matter, and this is a completely different animal because of Red Mesa's declaration of bankruptcy. And because of that, there's simply no reason to grant the application. This is not a Chapter 11 reorganization. There's no hope that this entity is going to come through the process as Red Mesa. This is Chapter 7. This is a liquidation. So there is nothing you can do here today that will make matters worse, contrary to Mr. Karakoff's arguments. The enforcement group tries to tread a fine line, and we try not to push operators into bankruptcy, but that's already happened here, and so there's no need for you to be cautious and consider this application. You should simply deny it. A couple points, and this is something I attempted to discuss in the sovereign case. Rule 707 is operator specific. It's not well specific. So whatever you order here today, and we ask that you deny the application, that only benefits Red Mesa. So a buyer coming along, that has no impact on them whatsoever. They are under the obligation to comply with 707 as the buyer the second they pick up inactive wells. So the only way you could impact that future buyer is an emergency rulemaking to amend 707 or something like that. So we don't want that, but what I'm saying is whatever you do today will not impact that future buyer. This was sort of alluded to in the objection that I'm a little worried you might not even have the authority to grant a variance on these facts. You would if you believed that granting the variance would not violate the basic intent of the act, but Section 106 of the act states that the commission shall require every operator to provide assurance that it is financially capable of fulfilling its obligations under the rules. And that's a mandate from the General Assembly. And Rule 707 was crafted to satisfy that mandate. But I believe it contradicts the basic intent of the Act and Section 106 to grant a variance to a rule that was designed to protect the state of Colorado from the future insolvency of an operator where the operator has declared bankruptcy. So, Commissioners, I'm prepared to go into the substance of the objection. And actually, let me touch on one point real quick, and that's the definition of shut-in or temporarily abandoned wells. This is an argument that appears in the application, and respectfully, I don't think it holds any water. A non-producing well in the state of Colorado is either a shut-in well or a temporarily abandoned well. And the only way you decide between the two is whether or not it is currently capable of production. So they've made some argument that some of these wells never produced, so they couldn't be one of these two options. I just don't buy it. These are the only two options, and so you end up in one of these two buckets. So I think Mr. Karakov just alluded to 4 wells. I think that's what he was talking about. These were the 4 wells that they were claiming had never produced and therefore didn't slide into the rule, and I think that's incorrect. But that being said, I could go through a similar PowerPoint presentation to discuss the deficiencies in the application, but to be honest, the 800-pound gorilla in the room is bankruptcy, and they have declared bankruptcy. So I feel like I might be wasting your time to go through the next 10 slides, but if you prefer, I can. Commissioners.
Sorry, I have just a quick question that I thought Brian Cave was representing these folks. Is Mr. Karakov is with another firm who is bankruptcy counsel?
Yes. So Brian Cave has no authorization to appear here today. Mr. Karakov represents the bankruptcy trustee. So their name appears there, and we should have included Mr. Karakov as well.
Mr. Karakov, may I ask your law firm and what representative capacity you're here with, just so I understand? This is Commissioner Spielman. Thank you.
Sure, Commissioner. The law firm is Archer and Greiner, PC.
Yep.
And we're here on behalf of the Chapter 7 trustee, Alfred Giuliano.
Thank you, sir.
Sure. Basically, Commissioner, what happens is when a company files for Chapter 7, the Office of the United States Trustee appoints a Chapter 7 trustee to administer that bankruptcy estate. And so Mr. Giuliano has been appointed the Chapter 7 trustee of the Red Mesa bankruptcy estate, and I am his counsel.
Understood. Thank you. We just didn't have that information coming in today. So.
I apologize.
Not at all. Thank you. Thank you, Mr. Chairman. I understand what's going on now.
Any other questions? The commissioners wish to hear the full presentation from Mr. Parent, or you have that all on your portfolio?
I've got videos this time.
Is this an enticement or what?
Just saying, FLIR videos.
Okay, if you don't want to hear that full presentation, is there, how would you like to dispose of this request for a variance?
You know, I guess you went to the effort of Capturing the video, perhaps we ought to at least see one of them. I don't know.
There you have it.
I imagine what it is just showing gas releases, right?
It is one of the wells shut in, still venting.
Probably have playing while we
So let me
proceed.
get it started. I think this is the better one. Well, why don't you proceed while I handle the technical difficulties?
Okay.
Can I ask Mr. Matter a question?
You may.
In my thought process here, you know, I keep going back to that one hearing where we had where the person who I guess was managing the bankruptcy went ahead and sold off all the producing wells and said that was in the best interest of the reorganization. And we got stuck with the single well that needed to be plugged. And that really upset me. So my question is, if we go ahead and deny to grant this application, and so we effectively put the $20,000, whatever, the bond on this idle well, on each of these wells, does that follow this, each of these wells? I know these wells are idle by law. This $20,000 has to be paid no matter what. But like we saw in the previous discussion, it kind of slipped through and people didn't know about it. If we go ahead and deny to grant this application, is that going to go ahead and make it more apparent to a buyer that even if they go ahead and bring this thing back, bring some of these wells back to production, that they're going to have to deal with us immediately? I mean, is that going to give it a little bit more notoriety that we're not going to separate this stuff so the possible producers get sold separately from the ones that have to be P&A and the state gets stuck with it?
I think you're sort of raising two different issues. In some instances, trustees do have the ability to abandon the bad apples and sell the good apples. The counsel for the trustee has referred to Mr. Holden, James Holden, who's the attorney for the Department of Natural Resources, is a bankruptcy expert who's been monitoring the case, and I've had some conversations with him. Mr. Holden believes that our view and the trustee's view are aligned in that regard, and that the trustee will not attempt to abandon the bad apples for the state to pay for it. I'm not sure. We don't control that. He could attempt to do so. But Mr. Farron's point of whoever the buyer is, there's going to be an obligation to post a bond commensurate with our rules. That's true. Whether that would chill the potential acquisition, I don't know.
That, as Mr. Farron said, doesn't make much difference what we do relative to that possibility.
So they could return for a similar application for variance, just like the sovereign matter, and they might have a more compelling case or a better plan or something. So, but the buyer certainly would need to come into compliance with 707. They would be immediately out of compliance.
I really hadn't thought of that. Thank you. Okay, folks, any other comments, questions? We do have a motion, or do we?
We do not.
I don't know. We do not have a motion.
Would you like?
So we'll just entertain one.
And want to close the record?
Oh, I'm sorry. We'll close the record on the testimony on the part of the parties and have deliberation.
My understanding is that this is the recommendation to deny the variance.
Deny the application for
Deny
variance.
the application for the variance. Then I would move that we deny the application for variance.
Second.
Motion and a second. Further discussion. Hearing none. Those in favor indicate aye.
Aye.
Aye. Opposed, same sign. So that application for the variance has been denied. Thank you very much.
Thank you for your time.
Thank you, commissioners.
Thank you.
Now, Ms. Murphy, according to my schedule, we have one additional item.
Yes, Chair, that's what's on my schedule as well.
And I think it's 3 to 5 minutes or
Visual.
I thought it was 35 seconds,
Oh,
but we might want to give Mr. Duranlo a little bit more time.
have already demonstrated excellent credentials relative to timekeeping.
Yes.
Thank you. I was guessing that answer was going to be humor, not timekeeping, but thank you.
Next agenda item.
Yeah, I'll try to say something relevant.
Thank you.
We will explain how we're dealing with this.
Yeah. So that's Director LaFleur is going to do that for us. Yeah, right. He's also going to define corruption, right? So commissioners, it's my fault, but this is on the schedule for you today. I looked at that extra hour and a half at the end and just thought you would probably want to work a full day. As you know, Executive Director King several months ago asked us to revisit Rule 604 C2EI, which talks about multi-well production facilities in a buffer zone. And that rule states that said multi-well production facilities should be located as far as possible from an occupied building. Following Director King's guidance, we have taken a hard look at applications submitted to us in which there are multiple well production facilities proposed in a buffer zone. And we have started to engage operators on that circumstance and look for solutions to perhaps putting those multi-well facilities a little bit farther away. It gets very tricky very fast, and that's what today's presentation is intended to just give you a couple exemplars. We're going to try not to name names of operators. We just want you to see the convoluted circumstances that this gives rise to and the difficulty of interpreting that phrase as far as possible and what that means and what our leverage is or is not to compel an operator to think about a different location than the one they have proposed to us, and quite frankly, in most cases, the one that they have an existing surface use agreement around. The good news is you don't have to decide anything on this matter.
This isn't a rulemaking or anything.
Correct.
Mr. Chairman, I have other obligations to the city.
The city.
The city, my city.
Yes, sir, I understood.
If I could be excused.
You may be excused. Yes, we don't. Yes, sir.
Thank you. Thanks. You can watch the video. Yeah, I will. I'm taking the front.
Thank you, Director, and thank you, Commissioners, for letting us take a little bit more of your time today. Greg Duranlo, Environmental Manager here at the Commission. To my left is John Noto, the Oil and Gas Location Assessment Supervisor here. And as Matt said, this is for your information. We've selected, or John's staff has selected, 4 sites which we feel have somewhat of a cross-section of very different issues that we're faced with when we review these applications. The one thing they all do have in common is they are all buffer zone oil and gas location proposals, so located within 1,000 feet of the nearest building unit. These are not necessarily all examples of what we'll be faced with in a future rulemaking of large-scale production facilities, whatever we choose to define that as, in urban mitigation areas. challenging nonetheless, and that's why we've chosen them to show you. So I'll turn it over to John and let him walk you through a few examples.
Hi, I'm John Noto. Thanks for the opportunity to present what we have here. Just a quick background on our mitigation measures. Of course, as you know, this 604 series mitigation measures, they go A through W, so there are 24 of them. The 604C to E is what we'd be talking about today, and that's multi-well production facilities in buffer zones, as the rule states, as far as possible. Our process has evolved in the form of what we require from the operators. Our Form 2A, which is where we are conducting this analysis, was updated on October 1st, and that's where we required cultural distances and the siting rationale. Working with operators, and there have been a lot of back and forth, so we appreciate the interactions that we've had with operators, has kind of led us to this point where we have some examples to present of some different situations where these are, we've taken all the identifying information off, but still the material information is here. So here we have site number 1, where we have a somewhat small scale facility in a buffer zone. The building unit that's in that buffer zone, and one of the ways that we do our analysis, it's kind of evolved to that, is we're drawing circles around building units now to identify a 500-foot and a 1,000-foot area around it. And with this one, you can see that the facility and the wells are in the buffer zone. This is not the surface owner's building. Property is very close to a boundary here.
John,
so we have.
I'm going to interrupt you. I'm sorry. Yeah, you need to slow down a little bit and let Greg get the pointer going. So it's very hard to just follow. So,
got it. Sorry.
So the surface owner. Okay.
And then this is the offsite building unit owner.
And there's the production facilities. So the surface owner has pushed these as far as possible from their own home, close to the adjacent property owner.
That's right. Thank you. So right now, this the siting rationale would be exactly that. That this is a surface use agreement issue that has been presented as the rationale. At the point of our interaction with the operators, we ask for more than that now typically, and we'll ask for the operator to provide a rationale for not placing production in other vacant land that looks available and that looks like it's practical, potentially from our review, just on the surface, of course, because we can only do a cursory review. The operator is going to need to provide us additional reasoning for their siting rationale. And I guess that gets down to our general approach at this point. We're working with operators, requiring more descriptive reasoning as we see the rule where they need to comply with this rule. We have had more challenging locations where the operators have provided very extensive rationale, and it was clear that they didn't have other options, and those Form 2As have been approved.
So in a little more detail regarding this location, and as you can see from this diagram, the well bores that are proposed from this oil and gas location are going to the north and off of this surface owner's property. So in this case, the oil and gas operator proposing to drill these wells has engaged in a surface use agreement off their mineral lease. So the oil and gas operator doesn't necessarily have a right to construct on this surface owner's location, but they have negotiated this surface use agreement granting them the right to construct. So the challenge that poses us is, because the surface use agreement is the sole right to construct in this case, then the deference has to be to the surface use agreement in placing those facilities where the surface owner wants them, which, as you can see, these production facilities located here could easily be argued as not as far as possible from this offsite building unit owner. But it's not as clear cut. The operator can't go back to the surface owner and say, I'd like to be farther away from your neighbor, because he doesn't have a right to construct other than that surface use agreement, which is negotiated with this party over here. So Matt, do you want to add to that?
I do, and I think that's very helpful clarification. And I'm not sure we know what the circumstance is as between the operator and the mineral owner and the surface above the minerals that are being developed. But the production facilities potentially could be located above the minerals on that surface, right? The operator has a right to that surface above the minerals, right?
That's correct. The challenge that places us in is we do and have always encouraged operators to negotiate surface use agreements. We think it's the best way to get onto the land. What Matt is essentially saying is the right to construct over these wells may be a bond situation where they're bonding on to do that instead of successfully negotiating a surface use agreement, and puts us in a interesting situation. So again, we're putting these things out as some of the challenges that are faced. And if you guys want to ask questions as we go through them, we'd be happy to take your questions, but I think we can kind of move on to the next example.
This next one, similar, actually very similar to the previous location, proposed location. In this circumstance, we have worked with an operator who has actually moved separators from one side of the pad to the other, but they stayed within their originally proposed location. So
these here,
those are
item number 10.
Number 10 got moved to the other side, placing it further away from the neighbor, the building unit owner that is adjacent to that surface. That was based on our request for them to give us additional siting rationale, generally based on that request, for them to give us additional siting rationale as to why their location, why it was necessary for it to be in the buffer zone, and how they were going to, how their rationale was basically in compliance with our rule. At this point, typical of many other locations, it's primarily surface use agreement. Surface owner is not the mineral owner, once again, but the oil and gas location does override these minerals. So there are some maybe additional options that the operator would have for placing production on this particular property and keeping it near their wells. I don't know if there's any more.
Yeah, so I think one important thing to add to this is, visually speaking, there is a lot of land outside of the buffer zones that one might argue is available to move these production facilities farther from this single building unit residence down here. Of course, moving it farther west does put it closer to a dense neighborhood. Moving it farther north may be an option, but again, it doesn't consider what the surface owner desires for their own land. In this case, it's actually platted in the town, and they are planning on subdividing. So, those considerations, what's there now is our primary consideration, to work with this building unit owner, and still retain deference to the surface owner to achieve the best results. John and Rebecca Treats, who is our oil and gas location assessment specialist, are actually going out to meet with the offsite building unit owner and the operator tomorrow morning. So, these negotiations and discussions are ongoing. They happen over a course of time. As Director Lepore indicated earlier, our permitting time is higher than we would like it to be. And I think, those types of negotiations certainly fold into the reasons for that, the complexities that we're seeing in these sites.
And yeah, just to add to that, these sites, many of them look very similar when they come in. We get a wide variety of public comment. Some of them I'm surprised that we don't see more comment. Some of them we see a lot of comment in what might be a fairly isolated situation. We are always encouraging the public to give us feedback, and then we always encourage the operators to respond to that feedback. So, next one. If anyone has any questions, feel free, but I'll jump to site number 3. It's a little bit larger facility. We are in a buffer zone and an exception zone with this one. This is another one where we've had interaction with a neighboring building unit owner who contacted me actually when they received their pre-notification. And we've been working with the operator on this. The operator is communicating with us. They have shifted they've moved their production similar to the last Form 2A. Right in the current proposed location is actually closer to the surface owner, there are 2 building units here. One is the actual surface owner, one is the neighbor. In this situation,
So up here, the surface owner is here, and the neighbor's residence is here.
Mm-hmm.
And this picture shows the originally proposed oil and gas location with wells here. There's actually a separate Form 2A with wells here. The common production facilities would be between those 2 wells and relatively close to this off-site building unit owner within the exception zone there. So as John said, this is the modified, based on our discussions with that operator. They've modified their Form 2A, roughly leaving the 2 rows of wells intact and hopscotching the production facilities farther away from the off-site building unit owner, roughly the same distance from the on-site building unit owner, or the surface owner's building unit, I should say.
And I guess I'd say that this is not uncommon. I think we're going to see more of this also, where staying within the boundaries that they originally negotiated with the surface owner is kind of the first step that the operators take. It might be the final step that they take and present to us that this is how they want to put their facility, plan it out, and then that's going to be their basic rationale. Is it comes down to a surface use agreement. That's where we start working with the operator to give us additional information so that we can do our review and process and pass these permits with the information that we feel is necessary for a siting rationale.
And so again, as you saw in the last example number 2, when you look at this, from a higher level, it does appear that there is surface that is owned by this building unit owner, who is the surface owner, that could be made available for the oil and gas production facilities, moving them farther from that offsite potentially affected building unit owner. And, again, as John was just saying, the surface owner and the operator have negotiated a surface use agreement, and this is where that surface owner wants those production facilities. And, it does put, us in a pretty difficult spot to look at those and start to work with the operators and try and pull some leverage to have them move them further away from an offsite building unit owner who, if you'll recall from our setback rulemakings, there was a lot of discussion as to whether or not those offsite building unit owners had standing. And it was clear that they don't have standing. What was also clear is that they do have rights, and they do need to be protected by our process. And so that's, again, the balance that we're facing.
So number 4 is the most interesting one. It's actually the largest of the 4. It will actually be in an urban mitigation area as defined by our rules, because there's a densely populated area.
This is a residential subdivision to the east.
It's buffer zone within that subdivision. Plus there are other buildings in the vicinity. In this situation, surface owner is not the mineral owner. Oil and gas overlie minerals. And once again, right to construct a surface use agreement. This is one that's going to be a challenge for the operator because of the surrounding area. And we're going to be working with them. This one's one of the more recent ones. As far as any work that's been done to try and relocate things or try and move any production to be further away, they haven't undertaken yet. They do have some limitations on where they can actually place their facilities, and there's some municipal restrictions, I guess I would put it that way. On one side, it's going to make it a challenge for them to try and go in that direction. Doing so would, of course, put them further from that subdivision. I don't know if you have anything else to say about that.
Oh, as John said, we've had, our staff has had discussions with the operator about this, and John and I have had separate discussions with the operator. I think this is a great example of the challenges that are faced. What isn't quite shown on this particular drawing is, these are, I believe, 2-mile laterals to the east, and there's sort of one parcel here in the middle of them that may also appear available for siting production facilities. But then beyond that, farther east, there are also additional subdivisions. So this particular example is probably more akin to what we're going to be discussing in rulemakings later this year. Large facilities, did you inventory this one? 24 oil tanks, 6 water tanks, 11 wells, 11 separators, over 7 acres of initial disturbance. So it is a pretty big site. This is a very dense community. There's also a large commercial facility that's a building unit here, and some additional challenges there. So that's all the examples that we brought, and would certainly be happy to.
I have a question.
Yeah.
This is really interesting, but I'm going to get to one of my pet peeves. Do you have any idea what the pressure of any of these wells will be? Because I can guarantee you that wells have personalities, and high pressure wells are very different than wells that need to be pumped. Do any of these wells have H2S? As far as I'm concerned, treating all wells the same, it's just not going to ensure the safety of the public. It's not. And particularly if you've got a whole slew of high pressure wells on the same well pad, and we're not using subsurface safety valves remotely operated in case there's an accident, I have a problem. And I can tell you right now, if any of these wells remotely have H2S and the radius of exposure for considering it becomes part of a neighborhood, whole different ball game for me. Because our number one priority here is the protection of the public in conjunction with the production of oil and gas. But this is interesting, but we are now starting to see wells that their pressure's getting me a little nervous, particularly in close proximity to people. And the surface owners negotiating the agreements, do they understand the difference between a relatively high pressure well and H2S and where the facilities are located? They may not. So that means the burden's on us. So I have a real question. I have a real concern. And right now with this information, it's interesting, but I got a whole bunch of other questions to ask.
So if I may briefly, I do share your concerns. And for one thing, the Form 2A does require that they tell us if they expect H2S. The Form 2s tell us that if they expect H2S. For the most part in this basin, we're not expecting H2S at the time of drilling. As far as whether or not they're high pressure wells, our staff, from the surface perspective, I would say generally we consider that the wells are going to be high pressure.
And I'm not talking Gulf of Mexico high pressure wells, okay?
So, and we aren't either, certainly. But we do look at those wellheads and say there are risks associated with the wellheads as well. That's taken into consideration in our review and in our rules. It's why we did include the BOP requirements in 604C. So we are considering that those things are what we have to review. I look forward to the discussions we're going to have for sure.
Any other questions or comments? So you anticipate a rulemaking post hence?
Wait and see how the legislature turns out.
Okay.
I want to point out one thing. If you go back to the area drawing on number 4. Yeah, that one. So maybe the most obvious place, if you were going to ask an operator to consider a location farther from the existing subdivision, it would be there where Greg is indicating. However, if you can read the smaller print there, that says Longmont. So Longmont currently doesn't allow hydrofracking. So, Counselor, you know all about extraterritorial impacts as a criteria for state interest. I would submit that as Exhibit A.
So now that begs a question, is that when you think about those well paths, you actually would not be fracking a formation within the city limits of Longmont.
And that question has come up, if I understand it correctly. An operator had a wellbore that passed into Longmont, and how do they elect? They elected not to stimulate that portion of the wellbore that was underneath Longmont. And I believe there's another situation, I won't speculate, but I know that case for sure. So how Longmont would respond, I think your question, Commissioner Benton, is could they build facilities, place well bores, provided they didn't fracture the well bores underneath Longmont, but were fracturing them in another jurisdiction?
Yes.
I don't know how Longmont would respond to that.
And Matt, to follow up on your example, it's the location that just happens to be to the north of this one, right here. This location, you can see that wells are drilled right on the edge of the Firestone-Longmont border. These are the well paths here that go off, and then they ultimately are completed to the east, and this portion that is underneath Longmont city limits is not fracture stimulated. Your question regarding the fluids and could we have production and storage of fluids from wells that are hydraulically fractured within the city of Longmont, I have no idea.
I think you couldn't have fluids, right? The ban extends to flowback on any fluid storage.
So you'd have to have some sort of way to transfer it off site or something like that, I suppose.
I don't know how you could stimulate the well.
Yeah. It's unfortunate that those minerals don't get developed.
All right, anything else?
So, not really. I'd say that, because of the interactions that we've had, because of the longer technical review times that we've taken, it takes an operator actually quite a while to get us new information, even to move their production facilities. A lot of these are beyond the 75-day review time that we have. We haven't had any requests for hearing from an operator. The operators actually are very anxious. The ones that we're working with are anxious to work with us. But I don't know what the future holds as far as whether we will see any requests for hearing concerning these matters.
Very interesting presentation. It does point out vividly your conundrum, our conundrum.
Just, I guess, last word I would offer is, from staff's point of view, one of the tools that we have is to elect not to approve the application and have them come before you for that. So
you can make that election based upon as far as possible.
I think if in my estimation they had not achieved whatever that standard means, and I don't think I know, but yes.
Talk about vague.
We will try and continue to work productively with operators and with their neighbors to hopefully prevent that from happening.
Appreciate your efforts. That's obviously a very, very difficult high wire to walk. Okay, thank you. I do have one announcement I need to make before we adjourn. We've been blessed with the presence of a young man in at oil and gas hearings almost as long as I can remember. And it's my understanding that Mr. Kent Custer has been recently recognized as the outstanding Department of Health and Environment employee for the last period. Don't know what goes on over there, but from what you do here, I think that's certainly a very, very good selection. Okay, ladies and gentlemen, is there anything else to come before us before we ride off into the proverbial sunset? Thank you. Thank you very much. We adjourn.